Welcome back, Crime Spies. Okay, so for those of you who use OBS and Restream, can you please explain to me why when you connect the two accounts and you schedule an event and it drops in a different spot? Question mark. FFS. Bing bong. Hi, Bobby. How are you? Happy Sunday to you, sir. Now, oh, goodness gracious me. Let's see. I refuse to put up a third monitor. There's too much space. Okay, so let me just add one thing here. View your channel live. Did it work? Oh my God, it worked. I wonder what I did. Okay, well, good. There, good. Never mind. Never mind my aforementioned. I don't know what's going on here. You know, I wonder if it's because I changed the. It doesn't matter. All right. Oh my goodness, people. Oh no. Well, I guess we'll see what happens here. Waiting for the host. What happens if I do this? I don't know. I better not mess with it. Oh, and another thing I just realized I forgot to do. All right, so let's just talk amongst ourselves. I forgot to change the destination for Rumble. Oh my goodness. Here I thought, oh, I'll just get started a little early today. Edit. Paste. So yesterday I did a couple live streams. I know people have been curious about the 2017 Gypsy Rose Blanchard, Mommy Dead and Dearest. Okay, looks like Rumble's working now. Hello on Rumble. Okay, there. My goodness. I did Mommy Dead and Dearest. Let's see what else I did. Let's put this up here so you can see it. Huh. Okay. Hi, Christine. Happy Sunday. Did you go to church this morning? I went to Murder Church. Talked to Steve for a little bit. What does this do? Either something really, really good or something really, really bad. As someone who works on computers, I hate computers. You know, I'm not super dumb when it comes to it. It's just I haven't had enough time to tinker as much as I would like to. And I really like being able to kind of customize the screen, albeit poorly. But, you know, I waffle because with Rumble, you do have to have a paid platform, like one that has like RTMP. If I only stream, ooh, I'm too loud. If I only stream to Rumble, you know, then I could just do it right through OBS. But when you stream on multiple platforms, you can use Restream, like Kick and YouTube. I could do those two together on Restream. But if I want to add the third element, the Rumble, I have to use a paid plan. They don't let you do custom RTMP. Now, Rumble has a static key that's in beta mode. And let's just say it doesn't work so hot. I might try it again. RTMP, here, yeah. Well, like I said, in OBS, you can do it direct if you wanted to, or like, you know, but when you add that third Now, if Rumble integrated with Restream or StreamYard, for example, then, you wouldn't have to monkey around. I mean, it takes just as long to set up Rumble's own live stream as it does to set up the whole works with the other two. I don't know. Maybe I should do a brainstorming session with some of you that are smarter in the computers than I am. But I do like, and I think this is, yeah, the witch. I haven't figured out how to get rid of the witch when I switch. The witch when I switch. Now, a lot of you like to use StreamYard. OBS or Restream is very similar. They have a studio, kind of pretty much the same thing, really. And I know a lot of you, like to put people's comments up on the screen. But, there's just when you're the only person back here working on stuff, you're trying to make sure that your, shit's working and you're going where you're supposed to go. And, I like this better where the little things pop up on the bottom. And I have issues with StreamYard. It'll tell me like I have one bar left, like the little, strength things. When I was using it, I'd have like full strength, but then StreamYard would say, oh, you have none or one barely hanging on. So I don't know. You could do a whole different thing. And then to learn OBS, I mean, you have to watch like 1,000 videos to find one or two good ones. On my YouTube channel, I do have a playlist for OBS of some that I found helpful. Christine, I did a test with Soloman on a live stream to see if it worked. Yeah, that's, like I said, I can't, I still have my free streaming thing. I hate web apps. Browsers do way too much now. Yeah. Well, and that's another thing. Like, I've got the Screamin' Demon computer. Xfinity likes to screw around. So it's running on my computer, where when you're up on the cloud, like in Restream Studio or StreamYard, I don't get the quality. Like I can stream in HD. It should be HD now. I know on Rumble you have to change the gear from, what is it, like one millibyte per. You got to change this down here to 4.5, and then you get better. Then you get the HD, and you're kind of like stuck also with the mercy of the video feed that comes. I don't know. It's a whole different thing. So let's get back to this. So I did want to mention yesterday, I'm so behind on things at home that I know a lot of people were interested in this Gypsy Rose Blanchard 2017 live stream or documentary from HBO. So I put that on. And then I did Natalia Speaks Season 2. We got the first 2 episodes in here. And then Xfinity screwed around with me when I was trying to switch episodes. So then episodes 3 through 6 had to be on a separate live stream. But they were, the Natalia Speaks is a follow-up to, in the description underneath is and thank you to Pixie78. I've asked for the duration of the Zachariah Anderson trial to please, in lieu of any type of Rumble rant, because I'm monetized over there, to please give to his fund. And Pixie78 gave a in lieu contribution yesterday. So thank you very much for that. I saw it. It was beautiful. Did I put it under here? No, I didn't. I'm old, but I must be getting older than I thought. Or did I put it in the comments? Season 1 is here. So we did season 1 in, I think it was June? Yeah, it's here. Now, here's the funny thing. So if you want to watch that, Natalia Speaks, season 1 is on the link in the comments. I thought I put it in description. And then season 2 we did yesterday in 2 parts. Now, it gets I had watched it. I'd kind of fallen asleep, so I'd watched it a couple, 2, 3 times. And then I remember the very end. I'm not going to spoiler alert it. I'm like, oh, that's so nice. And I must have gotten distracted and not paid attention to like the very last minute and a half. And I was just shocked at what I saw. So you're going to have to see it. Apparently now it's going to continue. I don't know if that means like there's going to be a couple more episodes in season 2, or if I have to wait a whole another, 6 months to get season 3. That was kind of shocking what happened at the end. All right, so here we are today, day 14. For those of you who don't have a lot of time to watch these trials, I don't even know how many hours we've had now. It's been a lot. We've had a couple 12-hour live streams. It's been a lot. And Dingleberry, I got to read you my Dingleberry poem. So Gravely is Dingleberry. And I had I added a description of Dingleberry to Chat GBT, and I asked it if it could please make a poem for me for Dingleberry. Let me pull it up here. Here, a poem for Dingleberry generated by Chat GPT. In the courtroom's shadow, In the courtroom's shadow, Dingleberry conspires. A prosecutor devious, justice he acquires. His arms flap with guile, weaving tales untrue. In the quest for conviction, innocence he'll undo. Mouthing words to witnesses, a sly charade, leading astray with deceitful crusade. A puppeteer, strings pulled with hands unseen. Dingleberry orchestrates a wicked legal sheen. Ferociously he drinks with when the truth eludes, thirsty for triumph where innocence intrudes. Not seeking justice, but a wrongful claim. Dingleberry's pursuit tainted by greed's flame. Thank you, ChatGPT. You did a pretty good job. And I didn't even ask you to put wrongful in there, but you did. Huh. Oh, I see Soloman responded. That's one of the better poems I have seen from AI. Okay, I'm glad you enjoyed it, Soloman. And again, thank you so much to the Anderson family for letting us use humor on occasion to heal our broken hearts. All right. Lastly, I want to just remind you it's been 1,329 days since Zachariah has been incarcerated. Please consider donating to the cause. The link is here, givesendgo.com/ZA Anderson. It's also in the description box below, or it's supposed to be. Clothing available. I don't know why I have that there. Non-monetary contributions such as sharing the link and prayers are also appreciated. The Sky Daddy listens and he answers. I know the economy stinks. I've given the story a few times now. Coffee, a thing of regular Folgers, black silk, well, any variety, frankly, is $11.49 at Cub Foods here in Minnesota. I checked yesterday and this morning. Give, Send, Go is 1,990 days away from what they needed by January 31st. Again, thank you so much to Pixie78 for your in lieu of contribution yesterday. I know Nicholas and David from MLS, Nicholas, the Swedish guy with Mr. Jingles, and David both contributed. I'm not sure because I know Nicholas was doing like shots of whiskey or something on Saturday. So I'm not sure if his is from, like if it goes into like a PayPal or something and then he puts it in. I don't know. But they're both on there. All right. So there's that. What else? I think that's probably it for now. So this is the final day of the defense, day 14. It's 2 hours, 54 minutes long. And, oops, I gotta change the sound. Boy, I gotta get my act together. It looks like we've got Daniel Bandy, Sergeant, Kenosha Police Department, Luke Courtier, Officer, Kenosha Police Department, Jill O'Hanlon, Detention Systems Managers, Connie Hillman, Zach's accountant. Ooh, accounting, my love language. Kurt Zellman, Deputy Fire Chief, Eric Quintana, Kenosha Detention Center. So we're going to get through that, and then I'd like to do closing arguments. After that, Legend Lurker, hello, and welcome to Crime Spies. Crime Spies, who doesn't really have her act together yet this morning. I don't know. I've been up early. I didn't sleep very well last night. And then after that is the verdict, and then the sentencing. Now, again, as I mentioned, in the description box underneath, I think number 3 is a link to the Wrongful podcast. I did notice yesterday that they are putting shorts from some of their absolutely masterful podcast episodes. There's 6 episodes. Part 5 was released in 2 parts on Wednesday and Thursday last week. Part 5B, I wasn't going to watch until I watched the whole thing, but I caved, and then I heard all these wonderful voices that are familiar to me through this true crime YouTube-ish journey. And then Broken Baker at the end tipped me over into the tears. And then after that, there's a bunch of voices, and then the waterworks turned on. So the sentencing is 2 hours long, and if we do get to that today, I would advise that you bring some tissues, because it's my understanding, what little I've heard of it, it's so sad. So there you have it. So like I said, it's almost noon here today. We've had a couple really long live streams with this journey. I think I can push through the rest of this. Closing arguments for Dingleberry, I might have to put on like 1.25 times speed because he's so annoying. And actually, before we get started, let's just do our little dance. There. Judge, I should have ChatGPT do a... How do you get those emojis or those things that are animated? That's pretty clever. Wait, I bet you're on Kick. Are you on Kick? That's probably why. That's another thing that's annoying with Rumble, is you can't integrate. You have to have a whole separate... Oh, you're on Rumble. Or Kick. I do like the Kick chat. The YouTube chat stinks. Your only option is to report or block someone. You can't hit reply. I've almost accidentally blocked my friends so many times. All right, so here we go. Episode 14. And if I can get through a long day, then today will be this will be the last episode. If I can't, we'll finish it tomorrow. There. Yeah, see, Kick's got those cute little animated emojis.
And yesterday afternoon I did...
oh, Lynn is here in Fraser Crane mode. Lynn is here in Fraser Crane mode. Hello, Lynn. Happy Sunday to you. Fraser Crane mode is the best mode to be in so you don't have to look at Dingleberry. Lynn, did you hear the poem? We get a new Kick follower. Oops. Now how come I can't respond to him? Or her, legend lurker. Huh, can't. Weird. That's dumb too. I've been on Kick for a couple months now. Chain of Custody is here. Hello and welcome. Did you hear my poem? The Dingleberry poem? Hello. Legendary lurker or legend lurker. I'm going to try to get over to Kick on my mobile to say hello. I do. This is actually a trial rewatch. Sometimes I do trial like actual watches, like the ones that are happening currently. I also do a lot of politics on Rumble and Kick. Usually, I don't do those on YouTube. Because I just don't. There is a subcommittee hearing coming up this week about the border. Actually, to be honest with you, I think the last subcommittee hearing I did it on all three platforms, and YouTube left me alone. But there's one coming up on the border. It's my understanding they're going to try to impeach Mayorkas. So politics and true crime trials. We did the Danilo Cavalcante manhunt for like a week and a half. That was insane. And then, I don't know, documentaries, audiobooks, stuff like that. But the true crime community is definitely growing over on Kick. And I do like it. It's just like a static link, so you never have to change it. I do like Kick is a great platform. I know Publicly Buzzed, he does Kick only live streams. He did like Twin Peaks, I think. On Friday. He did over Halloween, he did some Halloween movies over there. I'm trying to get him over on Rumble. I have to work on him. Steve, Publicly Buzzed. A protest stream? No, I usually don't get involved in that kind of stuff. I like to protest from here in the comfort of my home. Okay, so do you want me to read the poem again, the Dingleberry poem? I do. I went to a POTUS 45 rally. The one where there was a big riot outside Minneapolis. October 10th, 2019. Ilhan Omar wasn't supposed to be there, but she was. Okay, so do you want me to read the poem one more time for Dingleberry? I got to figure out how to move it now onto the screen. We'll do it one more time. This is a poem for Dingleberry, aka Gravely, Prosecutor Gravely, generated this morning by Chat GPT after I fed it some characteristics, let's just say. Okay, here. In the courtroom's shadow, Dingleberry conspires. A prosecutor devious, justice he acquires. His arms flap with guile, weaving tales untrue. In the quest for conviction, innocence he'll undo. Mouthing words to witnesses, a sly charade, leading astray with deceitful crusade. A puppeteer, strings pulled with hands unseen. I should have added small hands. Dingleberry orchestrates a wicked legal sheen. I don't know if I'd describe it as a legal sheen, but anyway, continuing. Ferociously he drinks with when the truth eludes, thirsty for triumph, where innocence intrudes. Not seeking justice, but a wrongful claim, Dingleberry's pursuit tainted by greed's flame. Thank you, Chat GPT. for putting that together. I do think that it's a little dance with the devil, but there you have it. Soloman did actually respond to that and said, that's one of the better poems I have seen from AI. I might have to still work on it. Sometimes you got to lead it. All right. So again, this is final day of defense witnesses. Looks like there's going to be quite a few. It's 3 hours, 12 minutes. I will bump it up as I can because I'd like to, this, it's just about noon now. I'd like this to move then to the closing arguments, the verdict, and the sentencing. So if I can get this all put in today's live stream, that would be ideal. Otherwise, I'll finish tomorrow. Good morning, Eris. I hope you are feeling well. I also hope you don't mind. There's a bot I programmed with one of your wonderful sayings that you have. Which one did I do? Hopefully the bot does its job. They pop in on occasion. Oops. Now I just closed it. Okay, so no, I don't know where it went. What is going on with me in my brain today? Oh well. All right, here we go, people.
Draft
Welcome
number
and thank
2
you.
of the instructions and draft
Yes,
number
you do.
1.
Well, you know what's interesting, Eris, is the more I like started looking, I'm like, well, basically, you could just come in and sit back, and if there's something I'm missing in my little some are faster than other ones, like the Give Send Go one's faster. Some of them are kind of, spaced out. But I'm like, why can't you just have the little bot guy do it? Then you can just relax. I don't expect anything. Although I'm a little weirded out by all these by all these wrenches. People are like, where's my wrench? People normally give me a wrench. I'm like, I don't even know who you are. What does it mean? I don't want one. Okay, here we go.
Of the proposed verdict forms, did everyone get a chance to look at those?
I received nothing.
Oh, hi, Shani Graham.
Oh,
How are you?
That's not
How
a
was your
statement.
Farkle
I did not
game?
receive anything from you.
That's not good.
I see. I
think
just
I fell
see now an
asleep.
email from 413, but
Just
honestly,
because I got up early.
did.
Where's my thing here?
Well, the instructions are as they were given. This is the written form. And the only significant change from the draft number 1 is
I wonder where it went.
the addition of the ones that hadn't been in before. The
Okay, thank you, Legend Lurker. Thank you
removal
so
of the
much.
references to defendant's testimony.
Welcome to Crime Spies and hope to see you again
205.
soon.
And the others you requested, other than prisoner as a witness. And those are the only changes on the instructions. The verdicts are very, very common.
Yeah, I just reviewed the verdict forms. Look good to me.
Oh, God, I don't know how to fix that. Okay, I might bump this up. You just closed the doc. Okay. I don't know what that means.
Okay, the district attorney's giving me a thumbs up, so that's good. Are we ready for the jury?
Nope.
Yes, Judge.
All right. In terms of steadfastness, we're going to hear the closing arguments of the attorneys. And because this is not evidence, no note-taking will be permitted for the duration of the trial. We follow the classical format, debate format in the courts. The district attorney
Oh, my goodness. Mucus.
bears the burden of proof, and because of the allocation of the burden, will be entitled to give the first argument, and then he will be
I don't know if I
given
know how
a
to play
second
Farkle.
rebuttal argument, which will be confined to answering the defense in its presentation. So it'll be the state defense and then the state again. And then I'll give you those couple of instructions, and the case will be turned over to you. Anybody have a problem having some food brought in? Okay, I'm going to do that then. Surprise.
Oh,
So
Judge
take care of
made
that, please.
another funny.
And with that, Mr. Gravely, you have the floor.
Thank you. Your Honor, counsels, ladies and gentlemen of the jury.
Wait. How is this closing arguments? What about our witnesses? Okay, so for those of you that watched, oh, because I'm on the wrong page. Oh, God, FFS. Oh, this is why nobody.
And Mr. Rivera are not here at this time.
This
Yeah.
is
Attorney
why
Rivera is here, he's
nobody
just not in the room at the time. Attorney Birdsall will be
follows
joining
me on
us a
social
little later.
media
Okay.
because
And
it seems like every day there's some shit
you ready to roll?
Judge, counsel has shared with us the outline of some of the witnesses. I wanted to briefly describe one witness that I suggest
Oh, look
may
at
be
this
relevant.
quality.
Ask the court to consider relevance before that person takes the stand, and then we are ready to go. So I want to make a very
Oh my God. Last week YouTube was telling me I was not connected to the internet, so I switched over
And,
to
Mr. Rivera are
I
not here at
switched
this
over
time.
to
Attorney Rivera is here, he's just not in the room.
I switched over to Rumble, and I was watching myself live explaining to my Rumble and Kick audiences that YouTube is telling me I wasn't connected to the internet. Also, one other thing I forgot to mention is if this has happened for me when I watch other channels, and I know it happened to a couple people watching the other day, if on YouTube all of a sudden the sound goes out or it starts making like this weird click and then the sound goes out, just refresh it. I don't know what's going on. Publicly Buzzed in Murder Church this morning, he said that Kick was having problems on Friday. I know Rumble's had like this weird where like the sync of the audio and video is off a little bit. You know, they say prepare for some type of it's weird. It's weird. So sometimes it is me though, because I'll hit the mute button in front of me instead of the one on the microphone. Okay, I've stalled enough.
Room at the time, and Attorney Birdsall will be joining us a little later.
Okay. And are you ready to roll?
Judge, counsel has shared with us the outline of some of the witnesses. I wanted to briefly describe one witness that I suggest may be relevant and ask the court to consider
LawKong
relevance before that
Express.
person takes the stand.
Did you hear
and then
my
we are ready to go.
poem?
So I want to make a very short argument and then proceed.
We have it at
That
1.25
witness is
times
Caitlin
speed.
Bryant. She is the landlord of Rosalía Gutierrez. What's been represented to me off the record is that what is about to be solicited is that Mr. Gutierrez was behind in his rent and faced eviction shortly before, or was going to face eviction shortly after the date of this incident. I'm going to suggest to the court that whether you are in good graces with your landlord and face eviction is
I can't stand this man. Shani Graham just said, "Shh, it's always IT." I think when I saw that I was live streaming on YouTube on Kick and Rumble, meanwhile I was like displaying the fact that YouTube was telling me I was not connected to the internet. That was probably like the one reinforcement that sometimes it isn't me. It's actually shenanigans, if you will. I gotta put up my shenanigans thing. And so last night I couldn't sleep. I don't know what's going on. And I made some notes because I re-listened to all of LawKong Express's 4 episodes. I thought, well, as long as I'm at the end, you know, of the defense witnesses and getting ready for closing arguments, I wanted to go through them again. And I took a whole bunch of notes on my channel. I don't even know if anybody can see them. And they probably don't make any sense. So I'm going to try to copy and paste those also while we're watching. No testimony from the landlord, despite the landlord can tell us if anyone complained about the blood on Rosalio's door. Yeah, that was another. I'm going to copy and paste this into the. I did find out today you can live stream to Discord too. I have to figure out how that works. All right, continuing.
Relevant for this case, and so that's the end of my argument.
And this
That's
would just
never
be
the end
going
of your
towards
argument,
the
Dingleberry.
police's lack of investigation into Mr. Gutierrez's financial situation. That's the extent of it.
That's very, very
Now here.
speculative that checking on the status of his rent
So we still have.
would
It's
lead to anything the jury
it's
could
me,
do in
Josie's in
deciding on the
there.
case. What am I missing?
There's been testimony about Mr.
Look at all
Gutierrez's
those beautiful
finances
faces.
that his mother assisted in providing him funds to go towards bills, rent, things of that nature. There's also been testimony that Mr. Gutierrez was behind, I think this came in with Detective Correa, that he was behind. He had several delinquencies on his TransUnion account. And so this is just furthering going that he was in a financial hardship position, which then gives credence to the fact that law enforcement should have looked into people that he owed money to. Like I said, I don't have anything further about the relevancy of the testimony.
It's the objection is sustained.
Okay.
Okay.
Then there are a couple of developments that occurred as far as witness availability. The defense had intended on calling Detective Anschutz back to the stand to establish prior inconsistencies. We were informed that the detective went out of state and is not available to come testify today. So the state and myself will hopefully be reaching some sort of stipulation as far as it relates to those prior inconsistencies. So I'm hoping to have something drafted up and ready to be read in by this afternoon, something that addresses both what the state and the defense would have wanted to come from that witness. Also, Officer Morrissey has been very ill, and so there might be a stipulation as far as his testimony as well. So, yeah, just wanted to kind of give the lay of the land to the court.
Okay. Many weeks ago, my wife set up a medical appointment for tomorrow at 12:45. That at that time.
Sorry, Doug, I can barely hear you.
At that time, did not appear it was going to collide with a 2-week case.
Funny, he's the only one gravely said.
So I didn't see any conflict. It's at 12:45 tomorrow, and so I probably will break about around noon, and we'll be gone for about 2 hours. And we'll start again at 2. Just so you know, they're going to lose a little bit of time tomorrow, and probably timing is terrible, but that's what's going to happen tomorrow.
2 hours from the appointment.
Ashley's here.
No, I don't think it's a long appointment, so
Okay.
I would hope to be back by 2.
Very good.
Is he going to get his head examined? Ashley, and it's me, Josie. So for those of you who are maybe new here or are listening on Rumble or Kick, we've been getting some really great views over on Rumble, and we had a new person in this morning from Kick. Lurking, Legend Lurker. So the message is getting out. Also, we're only... Pixie78 gave an in lieu donation yesterday watching Natalia Speaks. So $1,990 is left to go. Today is day 1,329 days that Zachariah Anderson has been incarcerated. Oh, it's Kick, K-I-C-K, not K-I-K. Maybe that's why nobody wants to go on it. I mean, also, why in the world would they name it Kick, K-I-C-K, and not when it's so closely related to kind of a, disturbing, let's just say, website. Okay, so I also wanted to say I did cheat. I cheated on you. I listened to episode 5B. I couldn't take it. I had to listen. And I had tears streaming down my face for quite a while. At the very end, Broken Baker broke the seal, if you will. And then all the voices at the end turned on the waterworks. That was beautifully done. Okay, so oh, Bobby, every time someone asks him a question, I imagine the dial-up sounds plays. Oh, wee oo, ka-dunk, 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 that one. Broken Baker's here. Yeah, you made me cry, sir. Yeah, that was, but it was beautiful. Broken Baker, he has a heart of gold. I am convinced now. All right, so here we have it. And also one other thing. So yesterday I listened to all 4 of LawKong Express's videos. The link should be in the description box below, unless it got broken like some of the other ones. And I made a whole bunch of notes for those ladies on Wrongful. I'm going to also make notes. I'm going to listen to yours all again today, or tonight, maybe tomorrow, and make notes. Like, I just wrote down these random things as they were popping in my head. And hopefully we can put that together. And I'm cutting onions. Get the yellow ones. They don't make you cry. Yeah, bakery. Okay, so see, I don't know what it was. Something in his heart came out into the microphone. It was beautiful. Okay, here we go. Don't make me cry now. I have like all day.
Be back until,
I'm not sure if
Okay.
I put the waterproof stuff on.
anything else?
Not from the state.
Not from the defense judge.
On the first day of spring, and also now that the college basketball season is over.
Oh, no wonder I hate him.
Well, I think
My ex-husband was a basketball player and a football player, 9-man. He actually went to college on a scholarship, and then just big long story. Anyway, he loved watching basketball, and the squeak, 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 bounce, bounce, bounce used to just drive me insane. I like watching basketball in person, not so much on the TV.
you were paying close attention.
I thought the NIT tournament was still going. That
I will slow the speed back down to normal when
Well, anyway.
appropriate.
We're ready for baseball. And we're ready to continue the case. So, Ms. Muller.
Okay, now I'll slow it down.
Thank you, Judge. The defense would call Sergeant Daniel Banby to the stand.
So close to that goal. I'm not sure if Steve, publicly buzzed, got my Twitter message this morning. I should have asked him when I was in Murder Church. I asked him if he could please mention it. He's got a gigantic, he also has a heart of gold. I love him. Oh, good. He remembered to swear the witness in.
Good morning, Sergeant. If you could just spell and state your name for that court reporter.
My name is Daniel Bandy, B-A-N-D-I.
He sort of looks like,
I'm a sergeant with the City of Kenosha Police Department.
what's his face? Matt Whitaker, the acting
I've been
AG.
a police officer for
Before Honey
I think
Badger
28
was
going on
sworn
29
in.
years.
Boy,
I've been
did
with
he
the City
turn
of
out to be a
Kenosha for the last
disappointment.
16.
And as a sergeant, how many years have you been employed in that position?
I believe 7.
Just jumping
gonna
right
turn
to
the
it, do you
audio up a
remember
little.
doing case in you remember doing work in the investigation of the disappearance of Mr. Rosalio Gutierrez?
Oh, man. We just started going. Okay, I've got full speed. A few dropped frames. What's up with that? Oh, God. Now that I'm finally done with all the things I was going to remember to say, this shit happens. It's Gravely? Yeah. Or it's YouTube. Vielhammer Media, if you're watching, can you start putting these on Rumble? Or Kick. They do save on Kick too. So you've got like backup. Oh my goodness. Here, talk amongst yourselves. I'll give you a topic. Dingleberry. Here. Journal entries. You know, I'm so sick of this stupid YouTube. Why? Why must it do it to me? Just watch now. I have to start all over. Oh my goodness. Let's see what happens now. Ah, see? Okay, now let's see if I'm still here. Okay, I'm still there. That's good. Oh, wait, it's here. Stop. Nope. Yeah, hard pass on that, YouTube.
The request was made, will have been a.
I hope to be back by 2. Leave it. Season. Guys.
And how are you currently
Second
employed?
verse.
I'm
same
a
as the
sergeant with the
first.
City of Kenosha Police Department.
Oh, the
How
picture's
long-
better too.
I'm reading that out.
Bobby, if you're still
I've been
listening,
a police officer for, I think 28,
that's
going on
another
29
tell. It's
years.
going to hit the
I've been with the City of
shitter.
Kenosha for the last
So
16.
the quality
And as a
goes all the way
sergeant,
down
how
and
many
then
years have you been employed in that position?
I
down.
believe 7.
Just jumping right to it, do you remember doing case in do you remember doing work in the investigation of the disappearance of Mr. Rosalio Gutierrez?
Hi,
I was
Scott
involved
McGinnis.
in
Welcome
that case
back.
as a supervisor, yes.
And can you explain to the jury what a supervisory role is like in this type of investigation?
Generally, as a supervisor in specific, I'm assigned to the Detective Bureau. And basically, I advocate for the detectives if they need supplies.
Scott McGinnis says, "Hi peeps, I can't watch my awful New England Patriots anymore. It's sad." Okay. Well, at least you had Tom Brady for a really long time. Us here in Minnesota, even our brand new fancy ass stadium we still can't manage to get to the Super Bowl. I miss the old days with Chris Carter and Randy Moss and Adrian Peterson.
Or if they need additional personnel, that sort of thing. I also inform our administration what's going on, explain to them the situation, keep them updated. That's my basic role. Occasionally I jump in and we'll talk to people or fill in.
Scott McGinnis just watched college football. It's way better. Actually, my son was in the marching band for the high school here, and they won the state tournament in 2020. Oh my God, I tell you what, those high school football teams are amazing. You should just watch those or college. NFL Red Zone to see good teams. Like I said, at least you had Tom Brady for a while.
Where detectives might need a hand.
We call the Vikings
in
the
this particular
Queens
case,
because they never seem to win.
what I did is a brief canvas of the apartment complex, talking to other people that were in the complex briefly to see if other detectives needed to go take statements from them or to follow up and speak with people that live there.
Okay, as far as your canvassing of other residents on the property, do you remember who you spoke to?
Specifically by name, no, I do not.
Did you speak to an individual named Jennifer Ziegler?
I believe that I did. It sounds familiar.
How about Nathan Hensley?
I believe so.
In addition to you canvassing individuals who lived at Wood Creek apartment, you also were overseeing other things that were occurring.
Yes, that's correct.
One of which the drone usage that Kenosha Police Department used to do an aerial search of the area west of Mr. Gutierrez's apartment.
I requested that the drone from the Sheriff's Department. The Sheriff's Department had the drone program at the time. They still do. I requested that they come out. I was not overseeing the operation of that, though. I'm not a licensed. I don't use that.
And why did you make that request?
The request was made very simply because it's an efficient way to search a large area rather quickly.
And did you ask that any
about
foot
thorough?
searches be done of the
How about efficient
surrounding
and thorough?
area around Mr. Gutierrez's apartment?
I don't remember. I probably did, but I don't remember if I did. And I don't think I specifically named that in my report.
To your knowledge, after the drone was used to conduct the aerial search, was there any information gathered from that helped in the investigation?
From what I remember about the drone search is that there was nothing found in the area that was searched. So in that respect of nothing being found, that was important in the investigation, yes.
Oh,
And
Sandra,
that was just the area
had a little
west, that
dusting of
wooded area
snow
west of Mr.
in
Gutierrez's
Minnesota.
apartment.
Yes, that's correct.
That there are other wooded areas around that area. To your knowledge, were those
Bruiser
searched?
Brody.
I don't remember.
I'm trying to do a moderator-free experience.
Do you remember overseeing
I have the little bots add all
around
the
May
little
21st, 2022,
goodness.
the pumping of the septic tank on Mr. Anderson's property?
Yes, I do.
And why did you, as a sergeant and overseeing this investigation, ask that that be done?
That the septic tank was pumped. That is a place that you could hide a body, and the tank had liquid in it, and so we wanted to look and see.
And did you find anything?
We did not.
Did you also ask, or did you ask about anything be done as far as the dumpsters on Mr. Anderson's property?
I don't know if I specifically asked about it, but I do remember that there was a dumpster on the property, and we ended up, I believe, emptying it out and looking through it.
Oh,
And why did you want to empty it out and look through it?
See what was in there?
And you didn't
did you
find
do a
anything?
luminol test to
Nothing
see
of
if a freshly
evidentiary value in this
unalived
case.
body
When you
was
say evidentiary
recently
value,
in
what do
there?
you mean by that?
There was trash that was in there, so the broad topic of is there anything in the dumpster? Yes, there were items in the dumpster, but there was nothing that I remember that was like bloody or, there was body parts or a gun or drugs or anything that would
It
be
had just been
illegal
dumped,
or
sir.
that was pertinent to this case that I remember.
Pause. I was reading reports yesterday. It was very interesting when the searches actually took place. Some friends to free Zachariah Anderson that live in Kenosha said the cops really didn't have search. Cigarettes are wet, and so was the septic tank. Okay, so this I'm pretty sure is in one of my many notes that I made. Sadie, okay, I find it, let's say, coincidental, but I don't really believe in coincidences. But, supposedly he went the bloodletting event happened on the 17th evening. all these people that said, oh, I was so worried about him. I was so worried about him. Why did you wait until the 19th? The 48-hour rule doesn't really apply anymore, or even 24-hour rule, really. You'd think between mom, you'd think the mom would contact, relatives or whatever, or, his friends would contact them. You're telling me that of all those people, even the Facebook girl who never met him, they all suddenly on the 19th decided that they were going to figure out what was going on. And then within just a very super short period of time, Sadie goes and discovers the thing, open screen door, knocks on the door, sees the soy sauce, which how in the world you can, really? Actually, now that I think of it, Michael and Erica had sushi. Do you eat soy sauce with sushi? I don't know. My brain is just going in so many different directions. But I just find it interesting. I also want to know if Sadie's cell phone records or geofencing records are available or they turned over. Another thing that really concerns me after seeing, what was I watched the other day? Where they're like, if it gets turned over to the defense, then that means it can be requested through FOIA. Okay, so who's the gatekeeper of all this information? In my opinion, the prosecutor defense judge should be in some type of area and go over and figure out what's relevant or not. Are you telling me that they're leaving it up to Dingleberry here to decide what's relevant to turn over? Question mark. I don't know. I don't know. But I'd like to know what time she got there. Remember she said in her testimony, I had to psych myself up. She was on the phone with her friend Becky, her bestie. And she had to psych herself up. Psych herself up for what? What was she anticipating? Was he even supposed to be home at 11 o'clock in the morning? Didn't he have a job? Of course, it was the Rona. All right. There.
I have nothing further
There's my
for
random
Sergeant
thought.
Vandy, subject to redirect.
State?
Sergeant Vandy, you were asked about drone search of a wooded area as well as whether other wooded areas in the sort of general vicinity of Wood Creek Apartments were searched. Since May of 2020.
And you spread like luminol all over Zachariah's van, but you don't spray the dumpster? The dumpster, what did we say? 11:07 was the call to 911, and I thought they said around 10:30 is when the dumpster got dumped. You're telling me that that's a coincidence? Because I don't believe it. I'd like to see what her cell phone records are. I'd also like to see if their geofencing that they conducted, which didn't sound like the guy even knew how it operated, the movie 2000 Mules, regardless of your political affiliation, very clearly explains the capacity of geofencing and how it's obtained and how accurate it is. I don't buy it. And if you think something was dumped in the dumpster, did you do any testing? Oh, we just looked. Really? Looked with what? Your eyeballs? Why don't you use any type of, luminol or something? And the dump, okay, remember when they stopped where the dump was or the garbage was dumping? Don't buzzards start flying around when a body starts to decompose? Or do they just fly all over the friggin', is there a specific kind of bird? I don't know.
Have any human remains been found in any of the wooded areas that would be covered in those questions, which you thought would cause one to need to compare it to Rosalía Gutierrez?
Not that I'm aware of.
Okay, and you would be aware of that, correct? As a sergeant at the Kenosha Police Department, if human remains had been found in any of those areas, you would know that.
That's correct.
How?
And you were asked about
with a drone?
The contents of a dumpster at the Anderson, at the Mequon address of the defendant. When you indicated nothing had been found, Was any carpet that had been cut out of that minivan on the property, was that found in the dumpster?
I don't believe so.
Okay. And were any clothing found in the dumpster, such as a blue checked plaid shirt or any of those kind of things?
Oh, there's
No.
that damn shirt again. The shirt that
I have
Sadie
no further
probably
questions.
has, which is why they keep using
Any
that picture
redirect?
and bringing it up.
Yes. Yes, thank you briefly. The state had just asked you about whether any remains have popped up in the area surrounding Mr. Gutierrez's apartment since May of 2020. However, since, let's say, May of 2020, have Kenosha Police Department or any law enforcement agencies, to your knowledge, continued to do any active searches for Mr. Gutierrez?
Yes.
And when was that?
I still,
Since the original incident, I don't know the exact dates.
So, but nothing this year in 2023.
Not that I remember.
okay,
And
if you've never found him,
nothing
how is
in
it?
late of 2022.
Again, I don't remember the exact dates, but it's not in my report. And, part of my function is to support the detectives. The detectives do a lot of the actual searching, and so I may or may not accompany them. So if, for
How
example,
about the lead
if we're going
detective
to
that
go out
spent
of
like
county
25 minutes there?
and do a search at a particular location, I would arrange for resources from that particular county, whether it's a fire department or a police department, whatever it might be. The specific dates, I don't remember.
And that's fine. And I guess what I'm trying to ask is, it's not as if every week there's a search party that goes out.
That would be fair.
And the additional searches that had occurred
I just
were
realized there was a
closer
software
to the
update.
May 19th, 2020 date.
I guess you have to be more specific in searching of where.
Sure. So were you aware of the searches that occurred near Harrington State Park?
Yes, I was.
So that was an additional search that occurred.
Yes, it is.
And that, to your knowledge, did that yield any evidence?
I was not part of, let me back up. I was not physically at that search. And as far as I know, there was no
348
evidentiary value
subscribers.
or anything of evidence that was
did that
recovered during
happen?
that search.
And then there was the search of the Greenview/Anderson tree farm.
Correct.
So that would have, in your knowledge, that was a subsequent search that was done.
There were searches done at the Anderson Tree Farm. That is correct.
And at Mr. Anderson's residence.
Yes.
And at the residence of Susan Brown Williamson.
I'm not sure I know who that is. If that's the Cedar Beach Road address, then yes.
But to your knowledge, I guess what I'm going back to is that outside of those searches that were completed by Kenosha Police Department, if you know, there weren't any additional searches that were done in the Kenosha area.
Well, there were searches of like electronics. I don't think that's necessarily what you're asking. As far as the physical searches, I don't remember any. Detectives may have gone out and searched without notifying me. But again, that's a specific question to a specific detective that I can't answer.
Nothing further, Judge.
Nothing on that.
You may step down.
Thank you.
All right, I'm going to pause. I'm not going to pause quite yet. So Ashley just said,
Call Officer Luke Courtier to the stand.
let's see here. Why did she email Zach around 7:30 on May 18th talking about spending holidays together? I think she was thinking Rosalía was ghosting her. I have that date written down from my LawKong Express notes. I still want to know what happened with the 80-year-old relative. Are they okay? How long did I think it was broken arm. How long did that take to
You
heal?
solemnly swear the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth. So help you God.
Camp.
Please be seated.
I gotta find my note. LawKong Express. Okay, so for those of you, this is another reason why I like having that little purple thing kind of bounce when new comments come up. It's probably annoying. I don't know how else to do it. But those of you on Rumble and those of you on Kick, it's super important that you see like what's happening in the chat. We've got Ashley, who's part of the wonderful Wrongful podcast. And I know Lynn was in here. LawKong Express has his channel with incredible insight on his 4 episodes of this. Broken Baker with his beautiful golden heart, and more. It's me, Josie, the voice. I could continue on and on and on, sprinkling praise. But that was something I wanted to look at. Also, just off the top of my head, I was thinking, Rosalio didn't he go buy baseball equipment? Yet no baseball equipment was found. I gotta figure out how to print my notes.
Good morning, officer. If you could be so kind just to state and spell your name for Madam Court Reporter.
Okay, Officer Luke, Luke, last name is Courtier, Cour.
Hopefully you're better than the last few we've seen.
And where are you currently employed?
The City of Kenosha Police Department.
And how long have you been employed with?
Okay, now I'm remembering that was another thing I had on my list. The Kenosha Police Department, what is like their crime rate there? Because in my opinion, the lead detective really wasn't a lead detective. The blood spatter guy didn't take his class until 15 months later. The judge fell down, went boom, had a, brain injury, yet they were quote unquote lucky to get him to sit on the bench for this. What's going on? Like, do they normally not have crimes like this? Is that why they're, like a clown show trying to do this? Number one. Number two, if they don't have the resources or the manpower or the experts, can't they go to the state level to ask for assistance? Just wondering.
The police department.
Approximately 7 years.
In your term of employment with the Kenosha Police Department, do you remember working on a case involving Mr. Zachariah Anderson?
I do.
And how involved was your involvement in that case?
I had a small part in it.
Small part.
Very small part.
And what was your small part, if you remember?
Who had a big part?
I was asked by Detective Kennedy to respond to the Kenosha County Jail and retrieve Mr. Anderson's clothing.
Okay.
Did you check Sadie's house to see if he left that shirt or anything else behind over at Sadie's house? ? Guarantee you that's probably why they keep using that picture. I'm not gonna lie, I'm a little disappointed with the defense. I'm telling you what. I'm getting the impression the closing argument was not very good either. And I think it was it the Wrongful podcast who mentioned how many times Gravely said maybe in his closing?
Anderson was wearing when he was arrested?
I'm not sure.
You examined them though, correct?
Correct, yes.
Okay. Judge, I do have exhibits that I would like the officer to open. I was informed that Detective Correa had taken the scissors. I don't know if we have another pair of scissors.
You are. Pretty good bag, will you?
I will.
And defense exhibit 299 to the witness.
Update, actually. If you have more to that, that's okay, right?
And if you don't mind just opening that, that exhibit.
Like I said,
Okay.
if Dingleberry is the gatekeeper of information, who here trusts him? Because I don't. Broken Baker, did you hear my poem for Dingleberry? The other day I was so mad I just started throwing trail mix in a peanut butter jar and eating it with a spoon.
Want me to remove them?
Yes, please.
Taking out my frustration on food. It was actually quite delicious. Actually, I think it was because Broken Baker, no, who was talking about if GIF is pronounced GIF or JIF. Oh my goodness. Look at that bright white shirt.
Can you
Oh,
explain
how does
what
that look?
that exhibit appears to be?
This is a
Incriminating.
V-cut white T-shirt, size large, with a George brand.
And is
George's Walmart brand. That's another thing. He's supposed to be at Walmart, you know, walking around, maybe, you know, breaking the rules when it comes to social distancing. But if he had a body in the back of his car, truck, van, if you will, with a white shirt on and flip-flops, for starters, blood is viscous. It's slippery. Number two, it was raining. Wouldn't that, like, exacerbate the blood problem? Number three, he's wearing a white shirt.
that the T-shirt that you had previously inspected?
Yes, it is.
And when you examined it, did you observe any stains or anything of that nature?
Yes, I did. I noticed a very small stain on the back right side of the shirt. It's like a light orange brown stain right here.
Was there anything else that you noticed about the shirt?
Not that I noticed, no. Well, I guess other than the fact that it appeared new. Basing that on the
It
fact
looked
that
to me like he bought T-shirts at
imprinted
Walmart, or that
tag
his shirt
on the
was
back of
dirty.
the collar is not faded at all.
And do you remember making a observation or determination about the brand of that T-shirt?
I do. I believe it was probably via Google, a Google search.
Who doesn't know that
revealed
the George brand is
this
from
brand
Walmart?
George is commonly sold at Walmart stores.
Walmart?
Correct.
And then were there any other things that indicated prior use, such as sweat stains or any other stains that you had noted?
Not that I noted at the time.
Matching pair at home.
How about now? Do there appear to be any, what appears to be sweat stains?
Yeah, there looks like there's like some yellowing on the bottom of the armpit area. That would be common with sweat stains.
Matching pair of flip-flops?
You can put that exhibit back in the bag. Thank you, officer. And I'm going to hand you what's
He's
been
just
marked
staring,
as
staring in disbelief.
300. And I'd ask that you do the same with opening it. Yeah.
Also, I think we talked the other day. Does anybody know, like, Dingleberry's ethics? Has he ever had any, like, ethical issues in his 30-ish years? Shocks me if he hasn't. Another thing I was thinking, you know, remember with the OJ thing, the commonly used quote, "If it doesn't fit, you must acquit." They should have done that with the body in the back of the van.
Okay.
Someone
you. Yes, if you
Rosalio
don't mind
size,
opening it. Yeah.
fitting in that
thank
little
you.
tiny piece of carpet, missing carpet. The body fit doesn't fit, you must acquit. I would think better of the neighbors to the east. The Packers.
Okay, and now are these the jeans that you previously inspected?
Yes, they are.
And when you inspected them, did you make an observation about the brand?
Yes, I did. I noted that it's Levi Strauss company brand. Size 34 wide, 32 long.
And did you make any conclusions or do any further, I guess, investigating into where those jeans can be purchased?
Again, the same way I did the t-shirts, quick Google search revealed that they're commonly sold by Walmart stores.
Did you know that Ralph
Thank
Lauren
you.
doesn't wash his jeans? Or barely ever washes his jeans? Can't remember where I heard that. Some random fun fact. Denim is not supposed to be washed very often, according to Ralph Lauren. I bet he's not a 34 waist anymore. He's probably like a 28, 29. He's so thin.
Okay.
Look what you've done, Gravely, you piece of garbage.
Handing the witness the marked as defense exhibit 319.
Oh my God. I just had an idea. Brace yourselves. Are you familiar with Project Veritas and their hidden cameras? Oftentimes, what do they call that? Honeypot? Honeypot things? Wonder if these officers would be fooled by some type of honeypot operation to get the truth out. You know, with the hidden camera.
I'm going to go ahead and open this one.
Yeah.
Who lives over in Kenosha? It's too far for me.
Can you
Oh,
tell
the
us
flip-flops.
about those flip-flops?
So these are the flip-flops that I examined.
That was on my
in
list.
that day.
Did you test them, sir?
Some of the
How many
things
pairs
that I
of shoes
noticed,
did you find at his home?
I'll say in addition to the colors, was that they appeared very worn, based on the fact that there's the foot impressions on make out each individual toe.
You know what
so
they say
appear to
about
be
big feet?
frequently
Big
shoes. Be
shoes.
worn. The
Ba-dum
other
bum.
thing that I noted was the two different sizes. This is the right shoe here.
I should have put tiny hands in the chat
Noted that it's
GPT thing.
size
Maybe
11.
I'll have it rewrite
and
it,
the left
including
shoe
tiny
is
hands.
size 12.
And did you notice anything about the
How if I was
brand?
creative
I
musically,
did.
I'd
Just
have the
based on
poem set to music.
the logo of it. I don't
Something
think
that
it had
includes like a
actually
cartoon chicken
written
sound.
brand name, but I did a Google search describing the logo that I observed, and it showed me a Google image photo of that same logo.
And
And
did
multiple
that
pairs.
search yield
I'm
any
sure they tested
information
all of
about
them.
where those flip-flops could have been purchased from?
I say that facetiously because I doubt it.
I don't recall on that one.
If I were to show you a copy of your report, would that help refresh your recollection?
Yes.
Oh, so the city of Kenosha is only 99,000 people? Fourth most populous?
So
Oh, I
it's
didn't know it was on
that
Lake
help?
Michigan. It's
cool.
beautiful
Yep.
there.
So
So Were you able to determine where these flip-flops and these were?
Yep. Yes.
Okay, and where was that?
So it's Athletic Works at Walmart.
Did they ever have
And
a
you said that
obituary
they're
for
to be
Rosalio?
heavily
Question
worn.
mark.
Yes.
Now, when you're inspecting these items, the jeans, the shirt, these flip-flops, why were you inspecting them?
I'm an evidence technician for the Kenosha Police Department.
How
So
much training have you
anytime
have?
that I'm taking,
Did you
you know, I
say
was
that already and I
assuming that
ignored it?
this was evidence in a case. You know, just taking note of anything that could be noteworthy of anything on the shoes or the clothing. So I could be descriptive in the reports. I didn't know if Detective Kennedy, who was the one that asked me to retrieve the clothing, had seen these for himself or if he's inspected them. So I needed to be able to describe what I saw so that when he reviews my reports, he would know what I saw on the items.
And you could put those back in the bag and I'll grab them from you in a bit. Is one thing that you're looking for, evidence of blood
I don't think he
stains,
did have very
other
many
stains,
clothes.
things of that
Shenny
nature?
Graham.
Correct.
He was known to be a very simple man.
And observe
Also,
stains.
it's a good question. Why were these pieces noteworthy? Did he not have many clothes? So, listening again to LawKong Express, one of his many fine episodes, they were talking about, you know, the Great Fire Pit debacle. And apparently, that home he was living in had some type of wiring issue. Why didn't they bring all of them? Well, apparently there was some type of pipe. I don't know if the pipe burst or leaked, and there was a bunch of his clothes were destroyed by mold and burned. That's my understanding.
On these flip-flops.
But his daughter testified he, you know, basically wore pretty much the same thing, almost always wearing flip-flops. Huh. I wonder how flip-flops in the rain, likely with, you know, viscous, slippery blood. Wonder how well you walk in those. My guess is probably not good.
Nothing that I would be able to say that was.
Oh, Shenigram, that was another thing. I live in the rural hills of San Diego, and oddly enough, we burn all our trash and stuff. City folks don't understand that. That's what I had asked, because even here in Minnesota, you know, if you get a little bit past out past the suburbs, everybody's got a fire pit, like big giant bonfires. They don't live close enough if they need to get rid of a chair or something to, you know, put it in the trailer and then drive it all the way to the city, bring it to the recycling center, pay $30. They just, you know, light a match. I mean, who doesn't love to have a big giant fire? And Wisconsin, I mean, my dad's whole family's in Amory. My dad had a cabin in Balsam Lake. That's what people do, is have fires. Only the city people really don't. We used to actually have to call the city if we were going to have a fire pit in our driveway. This is, you know, Crime Spies calling at address blah, blah, blah. We're going to have a fire pit. Okay. I think they abolished that like 20 years ago.
And the same question
Cleared
as it
spot in the
relates
land.
to the jeans. Were there any?
Yeah, cleared spot of land. Yeah, my friend lives in Big Sur, up on a big giant mountain. And they, you know, they don't have time to wait for the trash man. They figure it out.
Things that you saw?
Plus, on top of it, the ash from your fire pit is wonderful for your garden. I walk around to the neighbors. Hey, would you mind if I took all the ash out of your fire pit? I need it for the soil in the garden. We have a lot of clay.
On the jeans, no.
And then the shirt was just the orange stain on the back.
Correct.
And the yellowish stain near the armpits that you see now.
Correct.
Do you remember also inspecting a pair of underwear?
Yes.
Oh,
And do you remember any of the details regarding the underwear?
Yes, I do. I remember comparing to the other items of clothing, they appeared very worn or heavily used due to the elastic in the waist area was very stretched out. And then I also remember them being Fruit of the Loom brand.
And did you make a determination about any stores that commonly sell that brand of underwear?
Walmart, once again.
Walmart
And
and that could
Kohl's
be
and
a
Target.
question I don't want the answer to, but were there any
And-
stains of interest on the underwear?
Why are we
Not
talking
that
about
I
stains
noticed,
of interest?
Not that I recall.
And now when you had retrieved these items, they were in evidence similar to how they are today.
When I retrieved them from the jail?
Yeah.
No.
Okay. How were they when you retrieved them from the jail?
So at the jail, whenever you bring in an inmate in, all their items,
Yeah, see, all
belongings
of you
get
are
placed in like a
smart.
big blue, like it's almost like a mesh style bag. That's what I retrieved them from. And then I placed them in paper bags.
So you were, to your knowledge, were you the first person that did any sort of evidentiary investigation or looking on these items of clothing?
It'd be assumed that, yes.
And so kind of the chain of that custody was, correct me if I'm wrong, but was Mr. Anderson gets booked into the jail, his clothings get put into that blue mesh bag, and then you took them to inspect them.
Correct.
And then after you inspected them and reviewed them, how did you process the evidence from there?
So I'll start from the beginning. So I go to the jail. They hand me this blue mesh bag. I put gloves on my hand, on both hands, placed the items into bags, transported them to the Kenosha Police Department's Evidence Bureau, where we process all our evidence. Typically you would line, there's like a large metal table in there for our workstation. Typically we would line it with a roll of like brown paper. I remember that day we were out of that paper, so I obtained several paper bags, which fits the same purpose, and line the table with those instead, just to prevent any cross-contamination of any evidence from other cases. And then again, using gloved hands is when each item I started photographing and inspecting.
And then did you eventually at the end put them in paper bags and seal them?
Yes, I did.
Similar to the paper bags we see today.
Correct.
And so just generally, the items that you observed today appear as they did when you inspected them back in May of 2020?
Yes.
I have no further questions for this witness.
Yeah, Shani Graham summed it up here.
So officer, talk a little bit about obviously all the clothing,
Where's
the
my
underwear
mouse?
specifically.
Where's my rodent pointer? Shani Graham, I phased out. So these clothes became evidence because he was wearing them when you decide to arrest him. Got it. Exactly. Exactly. He was wearing them at the time he was arrested, so they must have been what he was wearing before. And another thing, they had him... Wait a minute. The Walmart video was on the 19th, wasn't it? Earlier that day, and then they arrested him that night. And supposedly he had the dead body in the back of the van? And that's the shirt he was wearing at Walmart? Or do I have the date wrong? Look up the date of the Walmart. This is the worst miscarriage of justice. I thought Tim Bleefnick had a bad investigation. I waffle a little bit with him. I don't think the state proved their case. I mean, there was some things, but I don't know. I saw him interviewed by somebody from 48 Hours, and he looked sincere to me, but maybe I'm just gullible. But this, there's nothing. Even the judge and Dingleberry prosecutor says the missing man.
Those were actually found in
How in the world can you go in prison
right pocket of
on
the
trial
jeep. Is that
for
accurate?
murder when
I don't recall.
they haven't even
Would your report refresh your
ascertained
Yes.
if that actually happened? Is this the worst?
Showing you a document pointing to the
This is
paragraph
why
of what I believe to be relevant.
this is why all of you really smart people, when you get jury duty, maybe we should try not to get out of jury duty. I wanted to be on a jury. I got kicked off. But you know, people always say, "Oh, I'm going to get called for jury duty." You know, and then they try to make an excuse that they can't serve. I don't know. Also, I said the other day, if these jurors can't seem to understand the system of McJustice and weigh out the facts from the fiction and the speculation from the truth, maybe bench trials are better in some of these cases. Although that wouldn't really apply to this judge. She probably would have had the same thing because Judge fall down, go boom. Doesn't know what he's doing.
Read that yourself, please.
I'm normally a really happy person. This just, every time I think about it, it makes me insane.
Does that refresh your recollection of where the underwear were found?
Yes.
Where were those underwear found?
Oh, yes, that's the one with
right
James
front
Gardner.
pocket of the jeans.
James Gardner. I've seen that one. I love that movie.
And the brand of those underwear were
Yeah,
the
jury
Loom?
duty is important.
Now, the jeans themselves in your report, did
I
you
think when I got
indicate
called, it was like
that
20
they
some
did
years
not
ago. I
appear
don't
to
even
be
think my
heavily
son was
worn and
born.
were possibly even
I
new?
wanted to serve.
Yes, I did.
And did you make that determination based on the general look of them and the fact that the Levi Strauss tag on the back wasn't faded at all?
Yes.
And then with the white V-cut short sleeve shirt, you also indicated in your report that it appeared to be very new as the imprinted tag on the back of the collar was not faded at all.
Correct.
Which obviously was in sharp contrast to the shoes you
Move
reviewed,
over,
which
darling.
appeared to
That's
be
the
very well
movie.
worn.
Correct.
Shani Graham. I haven't seen that in a while. That's a great movie. Doris Day, she's still alive. She lived in Big Sur. Monterey, I think.
I have no further questions. Thank you.
Nothing further, Judge.
Oh. Move over, darling. Isn't that what I said? Yeah, that's it. That's a great movie.
Yeah, why don't you go run and get some, and then we'll have you in the pool, kick you back. Oh, thank you.
Now is a good time to remind everyone that Zachariah Anderson has been in prison for 1,329 days. If I have remembered to update it the way I'm supposed to. I think I have. Maybe I should just do a quality check. Please consider donating to the cause. The Give, Send, Go link is right here. GiveSendGo.com/ZA Anderson. Also, it should be in the description box underneath. Bullet point 2, I think. Non-monetary, clothing available. That's what that means.
We have 2 additional witnesses. They
Clothing
will be
is on the
here at
website,
11
freezachariahanderson.org.
and 11:30 respectively.
Also,
last two
the Give, Send, Go
witnesses,
has an option
the
to
defense would
share
like to take
the
this time
link.
to be able to converse with Mr. Anderson about his right to testify at this juncture. So we there were the issues, Judge, with the 2 witnesses that we had anticipated going earlier. The one who informed us just yesterday that he's out of state, the officer witness,
Scott
and
McGinnis
then
is a
the other
Leo.
witness who appears to have the flu.
My ex-husband was a
So
Leo.
that's
He's
why
fire
our
and
other
earth.
witnesses
Guess what
aren't
happens
gonna
when
be here
fire
until
meets
11
earth?
and
Not
11:30
good.
respectively.
My mother was a Leo. His mother was a Leo. My triplet daughters are Leos.
Do you
Surrounded
have,
by them.
any rebuttal witness or available now? You don't have to.
Yeah, we told our rebuttal witnesses to be available at noon. So I think we do have two brief rebuttal witnesses. I might be able to get them here sooner, but they're not waiting in the hallway.
Well, your witnesses, have you called them and told them to get here sooner?
Yes, we have, one of them is at a
This
doctor's
volume is
appointment.
all over the
so
place.
He'll be here at 11:30, and then the other one is informed that we're ready to call, but they're traveling from out of.
Do you want me to?
County.
So mine are jail witnesses. I can see
Oh,
if I
more
can get them here
snitches?
sooner. I just can't guarantee it. They were told to come in.
No, I don't want to force you. Put
Oh,
your
Let's
case
Go
on earlier
Brandon's
than
here.
you're required to.
FJB. Did I tell you I had Let's Go
if they
Brandon
were-
put on my
you-
pumpkins a
you
couple
know,
years ago?
You get it from the jail.
It got like a big
20
giant
minutes,
pumpkin and
so,
then some of those smaller like squash, etc. Most of the
one
neighbors
is a
thought it was
records
funny.
custodian, so she's probably working right across the street. Should we at least try her?
Please.
So, okay, I'll call. Yeah,
Let's see if we can keep this.
We'll
Let's
see if
go,
we can at least
Brandon.
get her.
We'll make an
the
effort to keep
defense
this order.
so
But
far has
otherwise,
been
you're welcome to have.
not stellar.
Communication
Let's
is
just
that
put
the
it that way.
subpoena has expired, that he passed it on. I don't know what that. I don't have anything to do with their subpoenas. We certainly have not told him anything.
Oh,
we're
law
gonna try to
enforcement,
kind of
32
stick with,
years. Have you seen the
yeah,
movie The
cover.
Fall of Minneapolis? Scott McGinnis? Scott McGinnis. Have you seen The Fall of Minneapolis? It's at thefallofminneapolis.com. They crowdfunded it because they wanted people to see it about the Derek Chauvin trial. The gal on there, Liz Collin, is married to a friend of mine, Bob Kroll. He used to be the Police Federation president for Minneapolis. And her and JC, I always forget his name, were on with Megyn Kelly like a month or, well, it's been out probably 6 weeks now. And I did a live stream of that, of the Megyn Kelly interview, just kind of, you know, talking about, you know, different things that are brought up. I'm not a big, giant Megyn Kelly fan, but she was outraged too. So if you have a chance, watch it. Like I said, it's free. And the first time I was listening to it, their post-divorce, there was a police officer I had dated, and he's in that film. I'm like, oh my God, that sounds familiar. And then I read in my daughter's room, look who's on this movie. They're like, wow, that's a blast from the past. Yeah, so that was kind of interesting. So what I was hoping to do now that the holidays are over is connect Liz Collin, who wrote the book and now just did the documentary because, you know, she obviously knows how to get a hold of Megyn Kelly. Actually, when POTUS 45 was here in October of 2019, he brought Bob Kroll up on stage with him because Bob Kroll and all the police officers and the family had Cops for Trump shirts made up with Minnesota in the shape of a flag. If you look up the speech that POTUS 45 made in Minneapolis then, you'll see Bob gets brought up on stage. I should have called him and made his phone ring while he was up there. That would have been funny. Hopefully get some better attorneys with my money. Yep. Who had the flu, Douglas? To shovel snow, be back. Okay. Lift with your legs, not with your back. Hopefully you'll come back. Don't slip and fall. I don't think we're getting snow. We got a little dusting the other day.
Me? The doctors. I feel like I'm not in control.
But which week did you do that?
Who had the flu, Douglas? Oh, I bet it was Ann Schitz. Detective Ann Schitz.
We're not gonna.
Oh, I know that. But
What do I
for
win?
jury.
We're committed to making sure this happens.
Oh, and also it depends on if it's the fluffy snow or if it's that really dense stuff. That that stuff is not fun, like the half slush.
I think she'll be awfully short, so just so the court knows about it.
Okay.
I think she'll be very.
A while with him, so we may as well take her while she's here. So have them.
Thank you, Vielhammer Media, for editing.
The ordinary.
Let's do that. And for those of you in Fraser Crane mode, like Lynn, who's probably running back to her phone right now or iPad. All right, here we go. More of the shit show.
The defense presents its entire case before the state is invited to present any rebuttal evidence. However, because of the shortage we had this morning, the district attorney was kind enough to arrange for what he describes as a brief witness to testify at this point. So, Mr. Gravely?
State calls Jill O'Hamlin to the stand.
Oh, so we got rebuttal witnesses now? Okay, so can somebody please explain to me why they're under rebuttal witnesses already? And they haven't even demonstrated if the body would even fit in the back of the freaking minivan?
The truth, the whole truth, and nothing but the truth, so help you God. Please be seated.
Oh, well, he swore in this witness. That's good.
Ms. O'Hamlin, can you state your first and last name and please spell your last name for the record?
I thought we were going to have at least 4 hours
Jill
of
O'Hanlon,
dingleberry free.
JILLO_HANLON.
How are you employed?
I'm a detention systems manager for the Kenosha County Sheriff's Department.
What does that mean you do?
An array of things, but basically track inmates' activities.
Oh, John Gary's back.
From the time that they're booked to the time that they're released.
Hello, sir.
Are you the records custodian for records pertaining to where an inmate is located at any given point in the Kenosha County jail system?
I have access to pull those records, yes.
Okay.
Oh, no,
And,
I see. Thank
did you comply with the request to indicate specifically what cell 2 separate inmates were housed during a time period of February 2nd, 2022 through February 5th,
Not
2022?
compelled. Then who had
I
the
did
flu?
supply some reports from our jail management
Who had the
system.
dingleberry flu?
I'm going to show you first what's been marked as State's Exhibit 357. So that's the watch. Yep.
Hmm.
Ask you
Thank
if
you,
you
John
are
Gary.
familiar with this page document.
That makes sense.
Yes, I
It's
am.
about the only thing that's
What is
made
that?
sense so far in this trial.
It's a
in my
housing
opinion.
history report for Arquan, Washington.
Is that an official document of the jail generated by the system that you mentioned?
Yes, it was printed from the jail management system.
And is that a system that you regularly utilize to try to gain information about where inmates are located?
Yes, it is.
Do you find the system to be true and accurate regarding the reports it generates within your work experience?
Yes, I do.
And how many years have you been a person who operated this system or the equivalent system in generating such reports?
I've been involved in the records booking part for 22 years.
Turning your attention to State's Exhibit 357, does it appear to be changed or altered in any way from the document you produced upon the request of the DA's office regarding inmate Marquand Washington?
No, it does not.
So it appears to be unchanged other than the sticker that is attached to the document?
Correct.
I move admission of State's Exhibit 357, Judge.
No objection?
No.
Ms.
Steve?
Ms. O'Hanlon, utilizing Exhibit 357, can you indicate, first of all, what block that Marquand Washington was in from the dates of February 2nd through February 6th of 2022?
Mr. Washington was housed at our detention center. He was in H South Block, H West Cell, Bed 9.
And is that a security area, if you know, of the detention center?
That's our segregation unit.
Okay. And again, the cell number was?
The cell which was H West, the
Yep.
bed was 09.
And in that particular area of the detention center, when it says bed, does that mean, does that actually also mean cell number?
Yes, because H West is broken into cell blocks, and the bed number
I
would
wonder which
reflect
cell block Dingleberry's
the assignment on the
gonna find
bed.
himself someday soon.
So there are not multiple people within a cell, within a specific room in those locations, correct?
Correct.
Okay. So bed would mean you are in a specific cell under your cell.
Correct.
There.
And you indicated 09. Did I have that right?
Correct. 09.
I'm now going to show you what's
Dingleberry's
been marked in
poem.
State's Exhibit 358.
See if I can fix this.
And first ask you the same question. Do you recognize this document in the context of what we've been talking?
This is the inmate housing report for Nicholas McAtee.
Generated using the same system.
Correct.
Believe that 358 is true and accurate based on your experience and based on observing this document?
Correct.
Any changes or alterations other than the sticker that you see in Exhibit 358?
No.
Judge, I'd move admission of 358 based on the testimony.
Is there objection?
No, Judge.
Received.
And if I ask you about February 2nd through February 5th, 2022, up until 2:14
I wonder
p.m.,
if he can see this
are you able
poem.
to
He's probably
indicate
watching right now.
inmate Nicholas McAtee's location, again, from February 2nd, 2022 through February 5th, 2022 at 2:14?
Yes, he was housed in H West, bed 20 or cell 20.
So 20 as opposed to number 9, which was Mr. Washington, right?
Correct.
Okay. And then on February 5th, from 2:14 p.m. to 8:35 p.m., so 6 hours and 21 minutes, is there a movement to a different location within that same cell block?
Yes, that'd be cell 11.
Okay. And then at 8:35 p.m. On February 5th, is there again a move to a different location than number 11?
Yes, cell 22.
Okay. And again, those are also in the segregation unit, as was Mr. Washington.
Correct.
I have nothing else at this witness, Your Honor. Thank you.
Any questions?
Yes, thank you. So, Mr. Washington, based on these records, Mr. Washington and Mr. McAtee were housed in the same unit, that being H cell block, from February 2nd through February 6th of 2022.
Correct.
Nothing further.
Ms. O'Hanlon, and it was only in those 4 days that they were in segregation together. Is that correct?
Without itemizing the whole report and going through each cell location and transaction date, I wouldn't be able to tell you off the top of my head if they're housed together elsewhere.
You're not aware of any other time they were in segregation based on what you've been asked to look at?
No.
Nothing else?
The question was asked in such a way that the no could either be saying, no, they weren't, or no, I'm not able to tell.
No, I'm not aware of any other additional times they were housed together.
Thank you. Any other question?
No.
No.
Commissioner Stone? I think we're back at,
I was informed that our next witness has walked into the courthouse.
oh, splendid.
The record is going to be Connie Hillman.
Okay, there he is.
And
No.
on the record, I'd like to move into evidence exhibit 299 and 300 with the jeans and the white t-shirt.
No objection?
No.
Received?
Oh, now that's way on the bottom. So today has been day 1329 that this man here has been incarcerated. Some think rightfully and some think wrongly. If you could please consider donating, there are only $1,990 left away for the month of January to reach their goal. There is clothing available on the website. All proceeds go towards his defense fund. Non-monetary contributions such as sharing the link and sending prayers to your Sky Daddy also come in handy. When coffee is $11.49 for
Favored teams
Folgers,
in the NCAA.
it's understandable that money is tight. I think I know why I'm having a hard time here. Because I've got this. I have to do another overlay. Yeah, Shanigram, we do have a skeptic in our chat, although he seems to be doing fine for now. I thought he was coming around, and then it was very clear he was not. But it would be nice if we could get him to open both of his eyes, wouldn't it? None of us wants to live in a society where hive mind is the way things roll. That's no fun. How do we learn? Okay, that's a hair better. I'm trying not to get rid of this logo on the bottom, whilst still maintaining some kind of balance. So I think I have to do another overlay, different one. Plus Crime Spies is in Christmas. That's not right. While we are waiting and observing this fine man here, please feel free to read the Dingleberry poem to the left of your screen. I need to read it a few more times because I got to get better. Just wish the people who think he's rightfully are banned from ever enjoying a taco ever again. My God, I love tacos. They're delicious. All right, so for those of you who live by an Aldi, have you ever had their pineapple salsa? Question mark. If you take chicken and slow cook chicken in the pineapple salsa and then add that to your, soft shell taco, hard shell taco, what have you, it's delightful. And Bobby Bologna or Bologna, is it Bologna or Bologna? Here in Minnesota we say Bologna.
Would you raise your right hand, please? Solemnly swear the testimony you're about
Oh,
to
good. He
give
remembered
in
to
this matter
swear in
will
the
be the
witness.
truth, the whole
Have
truth,
I ever disclosed my
and nothing but
recipe
the
for
truth, so help you God.
I do.
Please be seated.
taco tater tot hot dish? It's
Good morning,
delightful.
Ms. Hillman. If you don't mind just stating and spelling your name for Madam Court Reporter.
Connie Hillman, Connie L. Hillman,
Ooh.
Hillmann.
She looks like I
And
did
Ms. Hillman,
a few
how
weeks
are you currently
ago
employed?
when I was bored and ratted my
I
hair
am
out
retired.
too much.
Very nice. What did you retire from?
I owned D&M Accounting Services in Menominee
Oh,
Falls,
she's an
Minnesota.
accountant.
And can you explain what D&M Accounting Services, what
Maybe
that
it's a big
business
hair thing with
entailed?
accountants.
Mainly
She's
doing
speaking my love
personal tax
language.
returns, corporate tax
It's
returns.
almost tax time. I'm
a
getting
lot of monthly
ready.
bookkeeping,
Good
payrolls.
times.
And
See how she's got her
how
accounting
long
shirt
did you
on?
have that company for?
32 years.
And were you the owner that entire time?
Yes.
I have many a tax story to tell you
In
about
your
my
32
clients.
years in business, did you ever have a client named Zachariah Anderson?
I did.
Okay,
Oh, and
did
she
you see that
smiles.
person in court
He
today?
must have
I
had good
do.
books.
Can you briefly point him out and describe what he's wearing?
Gentleman sitting next to you and looks like a gray suit with a blue
Pointing,
gray tie.
pointing at the accused.
Judge would ask that the record reflect that.
Right.
Thank you. So, you know Mr. Anderson, approximately how long had he been a client of yours?
I'm going to guess 2 years.
Usually when you find a good accountant, you stick with them kind of like a hairdresser.
Just for record purposes, since Detective Correa is not here,
I noticed that about her
am
cross too.
opening what's been previously marked as Defense Exhibit 242. Ms. Hillman, in your 32 years, I'm assuming there were certain business practices and procedures that you utilized
It's called GAP.
as far as keeping track of
GAAP.
clients' information, things of that nature.
Yes.
And all your shit has to be locked up with a key.
If someone were to do taxes with your accounting services, can you please explain to the jury the different ways that your client
He wasn't here today because he had the
come pick
flu?
up their tax return?
So you're saying I got the
Objection
first...
as to other variety
okay.
ways, certainly something
Oh, look at
specific to
Dingleberry
this
is covered
case,
up by
but,
his...
irrelevant what
by
other
his-
ways are available.
By his poem. Should I move it or should we just leave it
hold on.
there? Why don't we just leave it?
People can show up personally to pick up and sign the documents that give us permission to e-file their tax returns.
Mm-hmm.
Before we e-file a tax return, we need that signature, and they have to pay us either cash, check, Visa, MasterCard, Venmo, or PayPal.
Mm-hmm.
And do you provide a receipt for that transaction?
Only if it's cash.
You know what's really sucky? Is when you
So
spend
you
2 hours doing
update
someone's
work.
tax return and then you get to the end and you say, okay, well, it's, X amount of $100. Oh, can I make an appointment? And then they make up an excuse and then they don't come back because they know already what the answer is, basically. That sucks. That's happened a lot too. Well, when I used to work for a large chain part-time, that was a mistake.
Defense Exhibit 242. on this. Well, does this look familiar to you?
Yes, that is a receipt showing that the gentleman paid with cash.
Okay, and is this receipt, is that the type of receipt that your business
$243 doesn't
Correct.
too terrible.
And what would the date indicate?
May 18th of.
Was he a sole proprietor? I'm assuming.
And what would that indicate to you? What was done on that date?
That he picked up his, looks like his 2019 tax return, which I'm going to guess was more than likely filed for an extension because it would have been due
April
in
15th.
April.
Okay. And then
Although I think that
under
year they
this
gave you an
receipt,
extra thing.
is the document.
Unless you get money owed, then you have up to 3 years
Does
to
this
file
look
your
familiar?
return. Did
Yes,
you know
that's our
that?
tax return cover sheet that we
Doesn't apply to
put on
property
every
tax returns,
return
so.
that we do.
And it looks just like the ones that you do for your tax returns.
Yes.
And you had noted already that you did in fact prepare Mr. Anderson's taxes for the year 2019.
Correct.
And the address on this tax return,
Mhm.
is that the address of your company?
Gotta
Yes.
Get rid of the poem.
I want to show you this piece of paper as well. Does this look familiar to you?
Yes.
Can you explain what this is?
Oh.
It's just so that people
Oh,
have
I like that.
notification from us that they have 24 hours to look over their tax return. And if we don't hear from them regarding
I
any
wish I would have
changes,
had
then we go
that
ahead
on
and
many
e-file it.
occasion.
And then they can also log into a program we use called Secure File Pro, and that's where we store all PDF copies of tax returns for clients so they can download them at whenever they want.
Okay. And based on all these records and the receipt, is it your understanding that Mr. Anderson picked up this tax return packet on May 18th, 2020?
Yes.
Now, I want to talk a little bit about where your business was located. Was it a standalone building or was it in a strip mall? Like what kind of, sorry, it's very loud. Hold on. What kind of location was it?
It's in a Tri-City National Bank. It's a standalone building, and we lease the whole lower level of the Tri-City Bank.
And around May 18th, 2020, did you have any surveillance cameras or any security systems in place?
I believe we had security cameras, but we would not have had footage from that time frame, now.
Now.
Oh, that's
closer back
interesting.
to
I wonder if you could
May
see it in the back of the
18th,
minivan.
2020, did law enforcement ever come to your business to obtain that surveillance footage?
My guess is no.
Did law enforcement ever talk to you at all in this case?
No.
Oh, huh. Another
I have nothing
dropped
further
ball.
subject to re-correct.
Ms. Hillman, did you specifically speak to Mr. Anderson that day?
No.
So someone on your staff would have assisted him in giving him his tax return?
Right. The name on the receipt was Veronica Adamoy. She was the out front receptionist person.
Did your
But there's
detective
also a sticky note on the supplemental
your
page
detective
about when
interview her?
you filed the return.
see if he had
that
like cuts on
indicated
his hands or
We'll
anything?
stop in 3:24 p.m. call.
Adding to my
That's
question list.
Veronica's handwriting saying that she called him and that he must have made a notation saying that he would be in to pick it up.
And so that would be on the 18th, correct?
Right.
So at some point, she speaks to him at 3:24 p.m. and he says he'll stop in that day.
Right.
So then, per logic, you would stop in subsequent to that, sometime a little bit
That was
later
the
on.
19th, wasn't it?
Okay. So if his phone records put him in Menominee Falls at 4:52 p.m. on the 18th, that would be consistent
18th.
with him picking up his taxes from Menominee Falls on that day at that time.
Seems logical.
Oh, that's interesting. You'd think for sure. For sure he would have been busy disposing of that, missing man. Wonder what he was wearing. If it was like a white t-shirt and flip-flops.
I have nothing further. Thank you, Ms. Hillman.
Nothing further from this defense.
Too
May I
bad
step
they
down?
did. You didn't get the bank security
No,
footage
we,
because banks
when
wouldn't
do we
have
next
stuff
have
like
witnesses
that. So why
available?
bother asking? And taxes, yes, are an
Our next
absolute
witness
importance.
won't be there till 11:30, Judge.
I think that year the IRS gave people because of the Rona. I think they gave them an extension for a while, but it doesn't matter. Like I said, if you are owed a refund on your federal and state tax return, the April 15th is just a suggestion. You have up to 3 years to file it. If you, what did I say? If you're owed a refund. If you owe money, April 15th is set in stone unless you file an extension. There's your tax tip for the day. Excomber, CCC, hello, sir, or ma'am.
Witness is here.
Okay.
So we were thinking, Zellman, who's our last witness, read our stipulations in, will rest, and the state would be ready to call that jailer, and then we could be done.
It's a reminder.
Do that before we break.
And what about Mr.
You can take your call with him, or
I'll do it right now.
we'll do it all.
Okay.
So our proposal is, because we have all the stipulations worked out, defense, assuming that the colloquy goes in a certain way.
Speak in the microphone,
we'll all that
Dinkleberry.
done, then I'll immediately put on my jailer witness before they break for lunch, and then the court will be finished with evidence.
That's fine. All right. Mr. Anderson.
Here's the Dingleberry poem on the left for those of you who may have not had
person
a chance
accused
to
of
read
crime.
it.
Well,
Dingleberry
actually, any witness has a right
poem
to
generated this morning.
take the fifth. That's you hear that expression a lot. It refers to the provision in the federal Constitution, the Fifth Amendment, which allows a person not to give evidence against himself or any evidence at all. It's also in the state constitution. Bottom line is that you are not obliged to say anything at all in this case, testify in any way. If you decide that you do not wish to testify, there'll be no mention made of that unless you request that it be mentioned or one of your attorneys mentions it. If you decide to remain silent, I will not comment on it. The district attorney will not be permitted to comment on that. And the jury will either be given an instruction that they are to disregard the fact that you decided not to testify and may not consider it in any way in reaching their verdict. If you decide that you do want to testify, then the district attorney will be allowed to question you about anything which is germane to this case, relevant, pertinent, and that could even extend to matters for which you're not on trial. An example would be if it's relevant to this trial, and I've ruled some of it irrelevant, but if it becomes relevant to the trial, he could ask you questions about marijuana that if they're relevant, pertinent to the case, you'd have to answer and could not take the fifth on those. You can't selectively take the fifth on some matters and not on others. Once you're on the witness stand, once you testify, you can cross-examine as to any matter pertinent to this case, and you will have no right of silence with respect to those. I'm not suggesting that I would permit him to examine you about that.
What page are they under?
But if, as the evidence develops, he feels it becomes relevant,
Video
you can make another
entries?
shot at trying to let me testify, trying to get you, well, try to get me to admit evidence about that, and then in that event would be allowed to question you about it. So that's one thing. He can ask you also about any criminal record. Is there a criminal record? You can ask about a criminal record. You'll have to clear that with me first. or any recent act of dishonesty may be something that he'll be permitted to question you about.
Updates?
You understand that? Any question about this at all? If you decide to testify,
My internet hates me today.
you'll have a choice. Either I will say nothing
hated me
about it at
yesterday,
all, and the
too.
district attorney can't comment on it. No, what am I doing? If you decide to testify, the district attorney will be allowed to comment on your testimony. And you'll have the choice whether you want me to say nothing on the subject of your decision to
Okay, is there like
testify,
a secret code?
or
I've looked
no,
under
I'm sorry,
home, meet Zach.
Monday. If you decide to testify, then
Updates.
there will be an instruction given about weighing the testimony, which provides that your testimony should be weighed as the testimony of any other witness. Considerations of interest and other matters varying upon
Oh, I
credibility
didn't
apply to
see
the
this
defendant
page.
with any other, as well as any other witness.
It's not there either. Oh, look at all those
Pardon-
beautiful
pardon me?
faces.
I can hear you.
I instruct the jury that.
Oh, there's
just
David.
because the defendant is charged in this
David.
case should not discredit his testimony. That's the language you're talking about. It's up.
Yes, thank you. I knew
Wish
I was
knew
struggling
who
with it a
these
little bit.
people's names were.
So there will be some discussion about your testimony if you decide to testify but it will be along the lines that Mr. Ober has indicated.
Well, I can't find it.
Do you have any questions about this at all?
So it must be in some secret place that apparently I'm not smart enough to figure out.
I think all the questions I have.
Plus, I'll probably cry anyways. Probably good I don't see it now.
And I would like a little bit more time for them to
I'm not
consider
sure I have the
what I've asked
waterproof
them,
mascara on
but
today.
I will be doing whatever they recommend anyway. So largely it's going to be on their advice. And I think they're pretty clear on how things are going to go.
Okay, well, I'm going to continue the discussion now, and I'm going to rely on them to communicate to me what your final decision is. And you can't change it up to the last minute, but I need to know about it.
Dingleberry says one word about
So
it.
if your lawyer
That goes in the
says
mistrial
called you as a
pile.
witness, then I will take that as indicating that you have made a final decision one way or the other. If you call it testify, meaning that you've made a decision to testify and give up your right to remain silent. If she tells me that you don't wish to testify, then I will take that as an assertion of your privilege, and that will proceed with the case on that basis. Any question about this?
Well, I understand.
Has anybody threatened you or pressured you or forced you in any way?
Dingleberry.
Any way regarding my
A decision about testimony?
Oh,
Has
I
anybody
think he's the
promised
mind
you
reader.
anything
That's what I was
change all this?
thinking.
Is your mind clear today?
I believe so, yeah.
Are you feeling all right?
Good as that can be.
Have you ever been treated for a mental or emotional disorder? Where were you born?
I bet Sadie has.
And Port Washington? And
He has a way deeper voice than I
do you
anticipated.
have any questions at all about your rights here? I have to say I didn't do as well as I could have done in explaining it to you, but just so you understand, it's your decision and no one can force you in any way against your will. And even if you decide to overrule what your attorneys are suggesting, that's your decision entirely, and they have to accept it. And as do I.
Yeah, I think my attorneys gave me an excellent explanation. I do have concerns. I do have questions, but as far as testifying is concerned, I think they were very clear with me about that. And like I said, I would like a few more minutes to talk to them about a concern. I don't know how they're going to address it, but I think we're already basically on the same page. How things are going to go forward.
And it will have a little more time before the occasion arises for you to decide. But at this point, as I indicated, I'm going to assume that you're fully comfortable with whatever questions, maybe not what they end up telling you, but that you've been fully advised and you've made a decision based upon your own considerations and their advice.
Yep.
Okay.
Yes.
Any other question anybody wants to ask?
I wonder if
No,
Sadie
Judge,
trolls
Madam
these
We're just
trial
waiting on, I did send that
rewatches.
second stipulation to the clerk, so we're waiting on getting that. We can sign it and
It's
we'll be ready
covered.
to go.
So is
Well-
our plan then to present the rest of the defense case, including the stipulation, and then for the defense to rep and the state to try to present its witness before lunch?
Dingleberry,
Yes,
this poem is just for you.
but if it gets really late,
Lying piece of
we'll break for lunch
garbage.
before your witness.
Okay.
Okay. All right, I'm satisfied that Mr. Anderson is acting freely, voluntarily, and intelligently, understands the nature and qualities of his acts, and he needs a little more counseling with his attorney
Shanny Graham, I
situations,
like
and
that. Well,
then whatever decision he
let's
makes,
just say I share your
I'm
sentiment.
satisfied there is no constitutional impediment.
Hopefully she has night sweats.
Anything else before we start? I would rather just get that stipulation.
Karma does come
What's the
back to
sequence?
people. Sometimes it
We were
just takes a
thinking
little while.
Zellman, last physical witness, then I would
Zellman.
read in the two stipulations, defense would rest, state would call their last rebuttal witness.
I wasn't remembering the name. So let's go with that then.
Another sign
call it
that
jury
he
down.
isn't quite all there.
Defense would call Kurt Zellman.
Okay, I'm going to take my poem down. I need to go get some fresh coffee because this stuff tastes nasty. Hopefully...
Raise your right hand, please. You solemnly swear the testimony you are about to give in this matter will be the truth, the
Oh,
whole
good.
truth, and
He
nothing but the truth, so help
remembered
you
to
God.
swear
Please
this
be seated.
witness in. I'm
Good
making notes
morning.
there.
If you could just state and spell your name for the court reporter, please.
My name is Kurt, K-U-R-T. Last name is Zellman, Z-E-L-L-M-A-N-N.
And what is your title? Is it Mr. Zellman?
I'm the Deputy Fire Chief for the Southern Ozaki Fire Department.
Deputy Zellman would be fine?
Deputy Chief is just fine, yes.
Okay, great. Thank you.
Oh, that didn't.
You just said what your position is with the fire department, but if you can kind of go into what your position entails.
Kind of a jack of all trades. I'm number 2 in charge of the fire department.
Did he just call
I
Dingleberry a
oversee
jackhole?
both the EMS and the Fire Inspection Prevention
Freudian
Bureaus
slip?
and the training bureaus.
And you were kind of
Steven's
jumping
been
to it.
threatening
In
me
May
for
of
3
2020, you were actually called
For
to
reals?
the home of Mr. Zachariah
Do I need to put up
Anderson.
some kind of
That
censor
is correct.
disclaimer?
And you were called to put out a fire that
One
was
of those
on the
disguise
property.
masks I like to use in the chat.
I was called in as
The
support
mustache?
with our fire apparatus to make sure that the fire didn't roll. It was already out when I got there.
The fire was already out?
Yes, ma'am.
Okay. And
Do I
in
need to
this
lawyer up?
matter, were you ever asked
Our family
to
attorney
see if there were
retired.
any burn permits that were associated with
I'm gonna go
that
get coffee.
address of 6813 West Highland Avenue?
Yes, we did receive a information request for burn permits at that property.
And can you kind of explain what burn permits are for in the city of Mequon?
In the city of Mequon, we do allow open burning of only natural materials that originate from the property's residence or the property itself.
And these burn permits, is this something someone has to apply for?
Initially, yes, ma'am. Burn permit is applied for. We go out and inspect the property, make sure that it's suitable to burn, that they are within all the regulations, and then we issue the permit. Renewals are generally, as long as the person doesn't change any of the initial, we don't go back out and re-inspect.
So when you go to inspect, what are some of the things that you look for to pass someone for inspection for the permit?
That there's a containment system for the fire or rocks or something along those lines, that the size of the burn permit is within the, or that the size of the burn location is within the correct parameters of the permit, and that the setbacks are followed.
And if a permit is generated for an individual in the property, would that mean that they passed the inspection and that the burn pit had been inspected?
That assumption could be made, yes.
Okay. In looking whether the property and Mr. Anderson had permits, were you able to find any information about permits being obtained?
Yes, I was able to locate in our database the years that permits were obtained.
And can you explain the database for the jury? Basically how those records are stored.
It's simply an Excel spreadsheet that we add a tab each year for each year that a permit's issued.
And are those records accurately kept?
Yes.
The foundation.
Okay, great, thank you.
Yep.
I'm gonna hand you what's been marked. Well, before that, do you remember the years that Mr. Anderson had burn permits for his location at 6813 West Highland?
I'm sorry, I don't remember off the top of my head, no.
Okay, I'm gonna show you what's been marked as Exhibit 359. And this is Defense Exhibit 359. Can you explain what that is?
This is the form letter that each time a burn permit is issued is provided to the person requesting the permit.
And what year is this permit for?
2018.
And was there a time where you changed your database so that records previous to 2018 would not be accessible as far as printing out the permit records?
Yes, the database itself only goes back a few years. Before that, it was essentially a handwritten operation prior to my employment there. So I don't know exactly what year the database converted to electronic.
Okay, and that 2018 burning permit, when did it expire?
All burn permits in Mequon expire December 31st of the year of issuance.
And then for the 2018 burning permit, what was the address of the burn site?
This permit is issued to 6813 West Highland Road in Mequon.
And the resident?
Mr. Zachariah Anderson.
Okay, and did it have a note of where the burn pit would be?
Yes, it's noted as south of the house.
Okay. I'd ask that Defense Exhibit 359 be introduced or received.
Received.
Handing what's been marked as Defense Exhibit 360 to the witness. Can you explain what that is?
This is a burn permit for the year 2020 at the same residence.
Same residence, and is it the same resident?
Yes,
That would be Mr. Anderson.
yes.
And the note as to where the burn pit would be for 2020, was it the same as well that was south of the house?
Yeah,
And that burning permit would have expired on December 31st, 2020.
correct.
So I'm going to ask that Defense Exhibit 360 be received.
No objection.
Steve.
So can any resident of Mequon apply for a burning permit?
Yes,
And is that something that residents of that town have to do if they want to have fires on their property?
that is correct.
And to your knowledge, do a lot of people in the Mequon area get burn permits?
Check.
Roll.
Sorry, you can answer.
What's the lot?
Do you know the number of permits approximately that are issued every year?
I'm sorry, I don't, because our secretary is the one who does the issuance, so she keeps count. I don't.
In your work there as deputy chief in the city of Mequon for the fire department, have you seen people do burns on their property in the city of Mequon?
Yes,
And if they were to do that, they would have to have a permit.
that is correct.
I have no further questions subject to redirect.
Gentlemen, does the burn pit permit an individual to burn a bleach bottle or any container of bleach in their burn site?
No, sir, that would be not possible.
Okay, and what about clothes that have metal buttons on them? Would that be a permitted item to burn in any burn site that these permits involve?
No, sir.
What about steel-toed boots? Are those legal to burn in these burn pits?
No, sir.
And what about underwear and socks? Are those items legal to burn?
No, sir.
Okay, so those are not covered by the burn pit that you've been shown as an exhibit today. Is that correct?
That is correct.
I have nothing else, Judge.
In your experience of seeing people's burn pits and what they throw in it, if you have to put it out, is it common that in areas such as Mequon, people will burn some of their trash?
If they are doing so, it's in violation. I have gone to reports of items being improperly burned. Yes, so I have seen other people improperly burn items in the city of Mequon.
No further questions.
Do you recall the date of this incident? In other words, the time period of around May 19th, 2020, May 20th, 2020?
Are you asking about the time?
You recall going to this scene?
Yes.
Okay, I mean, you have your own independent memory.
Yes.
Okay. Had there been heavy rains the days before that?
Yes.
And you found that there was still a fire that required some intervention by you to allow people to go through it. Is that correct?
That is correct.
Even though it had been a heavy rainstorm?
Correct.
Nothing else?
I don't have anything else for Deputy Chief Soloman.
You may
Thank
sit
you.
down, sir.
The defense would like to read in two stipulations as far as it relates to the defense's case.
Go ahead.
Thank you. The first stipulation I will read is marked as Defense Exhibit 361, that the below signed parties stipulate on May 26, 2020, Officer Kyle Morrissey of the Kenosha Police Department obtained video footage from Casey's General Store, 280 Highland Drive, Fredonia, Wisconsin, and Ozaki High School, 401 Highland Drive, Fredonia, Wisconsin. The video footage was later reviewed and nothing of evidentiary value was located. This is signed by Attorney Michael Gravely and myself, dated today. We'd ask that Defense Exhibit 361 be received.
And is that agreed?
It is.
And as I indicated earlier, in the trial, several weeks ago, when something's stipulated, that's agreed by both parties as being accurate, and no further proof will be received on that subject to either bolster it or to question it. Any question about that? Okay, thank you.
The defense is going to read the second stipulation, which is marked as Defense Exhibit 364. It reads, the following are statements attributed to Detective Lauren Anschutz of the Kenosha Police Department, who is an unavailable witness in this matter at this time. The parties have stipulated that these statements should be read in their entirety to the jury in place of testimony that Detective Anschutz would have made if he had been available. On May 19th, 2020, Detective Anschutz interviewed O.A. During that interview, O.A. told him the following. Her brother was playing with Legos in the basement of her father's home because he likes it down there. He went down there to check on him. O.A. told Detective Anschutz that she never saw the unregistered gun and that she never saw any guns here in Wisconsin. In Detective Anschutz's report, he reported that during a phone conversation with OA on May 22nd, 2020, OA stated the following: Mr. Anderson never took the chainsaw out of the back of the van. In Detective Anschutz's report, he reported that on November 6th, 2020, OA stated the following: Mr. Anderson brought a chainsaw on the way up to the tree farm. When they went to the tree farm, Mr. Anderson and her uncle were fixing the chainsaw. When they left the tree farm, Mr. Anderson took a different chainsaw home. Once they arrived at the tree farm, Mr. Anderson borrowed Grandpa's work boots and took off Grandpa's boots and placed them in the van and took them home. She believed Mr. Anderson had a storage unit. Mr. Anderson told her he had to leave to go to the storage unit one day and returned 10 minutes later. That's a stipulation that's signed by attorney Michael Gravely and myself, dated today. We'd ask that Defense Exhibit 364 be received.
Okay, stipulated?
That is stipulated and
All right, they'll be received and are stipulated too.
Time the defense rests.
All right, and Mr. Rivley?
state has one witness. That is Officer Anna.
You tell me where the testimony you're about to give in this matter with the truth, the whole truth, and nothing but the truth. So help me God.
Yeah.
Please. Sure.
Can you please state your first and your last name and spell both your names for the record?
Eric Quintana, ERICKQUINTANA.
And Officer Quintana, where are you employed?
Kenosha County Detention Center.
And what's your position there?
Direct Supervision Officer.
And so, Officer, how long have you been employed at the detention center?
It'll be 5 years next month.
So I want to ask you about a particular area of the detention center called H West. Can you briefly describe what H West is?
It is a disciplinary unit. When an inmate commits an infraction, he is sent there for discipline for X amount of days.
And how many, do we call them cells in that area?
Yes.
How many cells does that unit have?
22.
22. And how are they tiered? Are they all on one level or are they on two separate levels?
1 through 10 is on the bottom, 11 through 22 is on the top.
And when an individual is in H West, and I'm speaking now about back in the time period of February of 2022. So if things have changed, please alert us to that. Okay. In February of 22, what was the arrangement for an individual who was assigned to H West? So how long would they be in their cell versus in other locations?
Usually sometimes like there'll be a malfunction and we'll have them move from a different cell. That's the only time they're moved.
Okay. And so how many hours a day are they in their actual cell?
23.
And then for that last hour then, unaccounted for by in the 24, what is happening to an inmate who is in H West?
It is their rec area. They're allowed to be in the day room where there are lines they cannot cross. They have to stay in a specific area.
And where are the officers, meaning jail staff, who would then monitor compliance with that? Where are those individuals located?
It's the officer station. We call it the bubble, and it's looking into the H West day room.
So, and I assume it has a vantage point where all of the cells are visible?
Yes.
And how many officers would be assigned to monitor H West at any given time?
2 officers.
2 officers? And are they both located in what you call the bubble typically?
Yeah.
All right. So I'm going to ask you to just orient me through a couple of pictures. And first of all, was a request made that you take a couple of pictures from the vantage point of particular cells? Was that what you were asked to do?
Yes, my supervisor instructed me to take 2 pictures from each vantage point.
Okay. And what did you utilize? What piece of machinery or equipment did you use to be able to take those pictures?
We have a body camera right here, and we're allowed to take pictures.
You're being asked to speak into the microphone a little more directly. You have a soft voice, and this is a hard room to hear it. Okay, so if you could speak up. So again, answer my question.
We have a body cam.
Okay.
And it allows us to take pictures when we change the options.
And did you do that upon our request?
Yes.
Okay. So I'm first going to have put up on the display up there what's been marked as State's Exhibit. Is it 362?
362.
362, officer. My first question is, did you take this picture once you see it?
Yes.
Did you take that picture?
Yes.
Okay. So what cell are you directly in front of and facing out from when you took this picture?
To my back is H West 9, and I'm looking into H West 20.
So if a person was assigned in H West 9, this would be what they looked out and saw from the very front of their cell?
Yes.
Okay. And is this picture, which is 362, is that a true and accurate copy of the vantage point from cell 9?
Yes.
Is there any changes or alterations from what you know to be the vantage point from cell 9 that in this picture, other than the sticker being on there? Otherwise, is it a true and accurate copy of what you see when you look out of 9 today and back in February of 2022?
That is what you would see. That's what I would see, but the inmate would be behind the mesh.
So his visibility would be even more compromised?
Yes.
Okay. But if you're right at the doorway and out of the doorway, this is what you see?
Yes.
Judge, I move admission of Exhibit 362 based on the testimony thus far.
No.
So from this picture, are you able to orient us as to where cell number 20 is?
Cell 20 would be over here.
Okay, so it's on the separate tier, correct?
Yes.
And it is that essentially as far across as this particular dorm or jail area takes you? It's on the far other end?
Yeah, it's the opposite side.
Okay. And it's upstairs at that location, is that right?
Yes.
So for 23 hours a day, an individual in cell 9 would only see the individual in 20 in the vantage point you've just shown me. Is that correct?
Yes.
Okay. So what if a person was moved to cell 11? Is 11 visible in this picture? And if it's not, then just please tell me.
It is not visible.
Is 11 the neighboring cell to 9? So it would be right next to it?
No, it would be above.
Okay. So 11 is, I see like a ceiling on this. You see what I'm talking about?
Yeah.
Okay. Is it above the ceiling?
Yeah.
Is it directly above 9, or is it directly above the neighboring one, which I assume would be 10?
It would be the neighboring one above.
Okay. So it's directly above the neighboring cell.
Yes.
All right. And then if one was in 22, where is that located?
22 is going to be way at the end. Right about there.
So that would even be slightly farther than 20?
Yes.
What would be the distance between cell 9 and cell 20 during those 23 hours a day? How far away would you estimate those two are in distance?
I would say approximately 50 to 60 feet.
50 to 60 feet. Okay. And is this a area of the detention center that you have worked in often in your career?
Yes.
Describe the ability of someone from 9 to communicate to 20 or 22. What tone of voice would you have to use in a normal situation to be able to get the people in 20 and 22 to be able to have a conversation with you?
You have to talk pretty loud. Basically, you'd be yelling because they're on opposite sides of the room and there's a lot of echo.
And what, if anything, can you say about whether that yelling would be something that other cells would hear? I mean, in other words, is there some kind of ability to yell in a targeted way, or would other cells also hear it if you yelled, again, from 9 to 20?
No, all the cells will be able to hear.
So if I were to simply whisper or speak in a very conversational voice, I had something confidential I wanted to say from 9. Based on your experience in this area, would 20 or 22 be able to hear me?
On a whisper, no. You still have to talk a little bit louder than normal just for them to hear you from 20 to 22.
Okay. From 9 to 20 to 22?
Oh, you'd have to talk loud.
Okay.
You're not going to whisper that.
Okay. So only if 20 and 22, which are close by cells, correct? Correct?
Yes, correct.
Okay. In this, there is, it looks like there's a red line. You see the line I'm talking about?
Yeah.
Can you just point out where that red line is for the jury? So just draw where that red line is so that they know what we're talking about.
The red line?
And does it go on both sides of the stairway there, that as depicted in this picture?
Yeah, it cuts off the stairs, then it cuts off part of the day room on the other side.
Okay. And what does that red line mean in the context of the rules or life in H West?
When you're on discipline, you're not allowed to cross those red lines for any reason.
And are people on discipline? Is that, if you're on H West, are you on discipline automatically?
Yes, most of the time.
Okay. So, are there ever times when a person who's housed in H West can go closer to that than that red line in the 1 hour a day that they're out?
The closest you'd be able to get without crossing it would be here and here.
Okay. And that's only for 1 hour a day at maximum?
Yes.
Now, if you're in the upstairs tier, are you allowed to walk into the downstairs tier during your 1 hour?
Yes, everyone's allowed to walk in that red area.
And if you cross that red line, then what happens?
One of two things. One, you get a warning. If you do it again, your recreation's over. Or you can just tell them it's over right then and there.
And does that come from the 2 people up in the bubble?
Comes from one or the other.
Okay. And is this something that you believe is regularly and consistently enforced?
I enforced it, yes.
Okay. I'm going to show you now what's been marked as State's Exhibit 363. And just let me know what this is in relation to this case. So what is Exhibit 363? First of all, is this a picture you took?
Yes.
Is it, again, a true and accurate vantage point from the place you were situated when you took this picture?
Yes.
Does it accurately reflect the distances from one end of this cell block to the other and where the cells are that are in question in this case?
Yes, it is accurate.
Do you think it's changed or altered in any way other than the sticker that's on there?
No.
Again, I'd move admission of 363 based on the testimony, Your Honor.
Okay.
Yeah.
So from 363, what is our vantage point?
You're standing in front of H West 20, looking at H West 9.
Okay. I think we locked you in the microphone. So one more time.
I'm standing in front of H West 20, looking at H West 9.
So where is H West 9 on this photo? So the jury knows where a person who's in 9 is located.
Right about here.
Under the stairwell and on the back, towards the back wall?
Yes, in that corner.
So it's the far corner under the stairwell?
Yes.
Are there occasions where two inmates are ever out for rec time at the same time, or is that something that is forbidden?
No, that is not allowed.
Okay. Where is 22 on this? If you can see it, where's 22 on this particular exhibit?
You won't be able to see it. It's 2 cells this way, like to the left.
And the red line that we're depicting here, is that same red line we saw in the other picture?
Yes, it is the same red line.
Just a different vantage point?
Yes.
Okay. I have no further questions.
Thank you, Judge. I'm going to keep 363 up. The state had asked you that this is the vantage point from cell 20, correct?
Yes.
And again, that's from outside the cell, not inside.
Correct.
Because a view from inside would be obstructed.
Yes.
So if the state had asked you about the noise and stuff like that, and you're familiar with working in H block, right?
Yes, I'm familiar.
And it can get, you said, echoey.
Yes.
And so if someone says something and it is not a whisper, chances are other people in the unit are going to be able to hear it.
Yes, correct.
And so if you're in a cell and you hear something coming from a different cell, it might be difficult to pinpoint exactly what cell it's coming from.
Yes, correct.
It's only potentially that you can know who it's coming from based on your experience by sound of the voice, if they're saying who it is, those type of identifying factors.
Yes.
And so coming here then from the picture we see, can you see cell 11 in this picture?
Yes, I can see cell 11.
And can you point out to the jury where cell 11 is?
Right.
Okay, and then where is cell 9? So these are relatively close to each other, just on opposite tiers.
Yes.
So before the state had asked you that if you're whispering or talking quieter from cell 9, would it be difficult to hear in cell 20? You gave an answer. But as far as with cell 11 and cell 9, individuals would be able to speak quieter and maybe be heard just by those cells.
You'd have to talk a little louder, not as loud as 9 and 20, but you still have to talk fairly loud because they're on opposite tiers.
But not, you don't need to yell.
Correct.
How often did you work in H West?
I was pretty often on it on night shift. I used to work it.
A night shift?
Yeah.
Okay. And the state had asked you about the rules about rec and staying inside the red lines. There are times where individuals housed in H West do go outside those lines.
Yes.
And some deputies and correctional officers, some of them might not say anything.
I'm give them a warning.
A warning, but they're not gonna, some don't enforce it as heavy as others, correct?
Yes.
That'd be a fair sentiment.
Yes.
So there are times where other inmates do go up to the cell doors of the others.
Yes.
And they talk to one another.
Yes.
And this would be during the rec time?
Mm-hmm. Yes, it would be during rec time.
Okay. When people get transferred in H West, do you have to update the records?
Yes, we do.
And so if someone gets switched in between shifts, it would be the next individual that has to update the change?
No, it's the officer who made the switch updates it.
Okay, and do you update that immediately or at the end of your shift?
I updated immediately.
Okay. And you also had talked about how you had a request made to take these photographs.
Yes.
When did you receive that request?
It was on Thursday before my weekend off. Supervisor called and then instructed me to take pictures, and I did with my body cam.
Okay, just this last Thursday.
Yes.
I have nothing further.
Questions?
So during rec time, is a person who is residing on the first floor able to go onto the second tier ever?
No, they're not allowed to do that.
So that's never permitted.
No.
And if and did I hear you correctly that based on the mesh and the obstruction and the echoes and so forth, that you believe that it is often difficult to tell which cell is communicating with another cell? In other words, if you're in a cell, you might not know which other cell is talking to you?
Yes.
Nothing else?
I have nothing further, Judge.
You may sit down, sir.
Your Honor, the state has no further rebuttal at this time.
The defense has no rebuttal witnesses, Judge.
Right. Let's take a break at this time, and I'm going to ask that you return at 2:00. Please don't discuss the case with anyone, not even another juror. Rewatch the lesson when you come to the trial. Any questions? Thank you. I think I could have done a much better job than I did. And it's important enough that I think it needs to be recovered. So that you understand, your options are that you can testify in the case if you want to. If you do decide to testify, then the district attorney would be allowed to cross-examine you, question you about anything which is pertinent to the case, which could involve matters for which you are not on trial, and you'd have to answer those questions. He would also be allowed to question you about any matter, recent event, which would be suggestive of dishonest behavior, and you'd have to answer those questions, even though they don't directly relate to what is on for trial here. And he could question you about criminal history, and he'd be limited to asking you if you've been convicted of crime before and how many times. If you correctly answer those questions, that would be the end of it. If you did not correctly answer those questions, then he would be allowed to go through and identify specific crimes, dates, and places of conviction. Any question about any of that?
No.
Okay. If you decide you do not wish to testify, then there'll be no cross-examination. You won't be questioned about anything about this case. And you would have the option for me to instruct the jury that your silence must not be considered in any way. Defendant in a criminal case has an absolute constitutional right not to testify, and his silence must not be considered as evidence against him in any way, or be considered in any way by the jury in deliberating on their verdict. You understand that?
Yes.
I would give that instruction only if you requested it. If you did not request that instruction, then I would not mention anything about your decision not to testify in the case. Understand that?
Yes.
The district attorney would not be allowed to comment at all on your silence if you decided you did not wish to testify. You understand that?
Yes.
Any questions about this at all?
No.
Have you had enough time to discuss this matter with your lawyers?
I believe so.
And have any questions that you have been answered to the best of their ability and your satisfaction?
I believe so.
Okay. Any question anybody wants further asked?
Judge, I would just say that we, as a team, have talked to Mr. Anderson about all the pros and cons, just like the court laid out, and so it's fully informed, knowing that.
Okay. Anything that you had to comment?
No.
Okay. then what's the plan when the jury returns?
So will jury want to have a conference with us?
I proposed, I hope, to send you electronically proposed instruction draft number 1. I hope so. I hope you have within about a half an hour, so you have some time to review it, and then we will discuss it when the jury when we return. Given what you've already sent me, I don't think it'll be too lengthy. And anything else?
Well, I think that the parties just want to know what is contemplating this afternoon. So, is the court hoping to instruct but have us argue first thing in the morning, or is the court still hoping to argue this afternoon? What is the court's preference?
I think it.
Would we be back?
I think it's unrealistic to try to complete everything today, and I don't want to break the arguments up. So yes, I will instruct this afternoon, and then we'll start with argument in the morning.
Yeah, that's fine with the state.
And I won't put a time limit on you, other than when I was a young man, I used to. We lived across the street from Kenneth Brew, who was an eminent federal judge in Milwaukee for many, many years. And I would shovel his snow. And the only advice he ever gave me, even though he knew I was in law school, was, I think he probably said, stick to shoveling the snow. But he said, the brain cannot absorb what the seat cannot endure. So I think that was wonderful advice from him, and I'll repeat it to you. So,
and Judge,
and I do need to leave here at high noon tomorrow.
Yeah, understood.
I need tomorrow, that's fine.
Wow.
Just because you're going to be drafting up those jury instructions, the defense would be seeking instruction 315.
Yes. Okay.
Just so you know to include that.
Sure. Yeah, you should have them within.
Do you want us back here physically at 2 as well?
At 2:00, yes, be back. And I did not ultimately. I didn't want to give 2 separate instructions on counts 1 and 2.
Okay.
But I.
The more verbose one for both of them?
I am giving the standard, but I'm going to omit the paragraph you deleted from both.
Okay, perfect.
Are you reading the card?
Yes, thank you. Yes, thank you very much. Send you proposal draft number 1. It's supposed to have a stamp on it, draft number 1, but I guess I forgot to do
Boy,
that.
I'm having a really hard time with this browser.
Then, oh man. I also didn't number the pages. But anyway, has everybody received copies?
Yeah.
A couple of preliminary matters.
Is this going to be jury instructions? I wish I could sign in on my other window here. I don't know what's going on. Well, let's just say, in my opinion, the defense witnesses didn't do a good job. If I was them, I would have done some sort of back of the minivan recreation. If the body doesn't fit, you must acquit. Check your device. Yeah. All right. Here. Time for this. And in case Lynn is running to her phone, 3, 2, 1. There. Thank you to the Anderson family for letting us make fun of the judge without disparaging your poor brother here. All right. I don't know what's going on with this browser. Let's just take a look, see. Oh, and as soon as I said that, here it comes. Oh, I lost one subscriber. That's okay. It's taking me this long to get to 347. What's another 9 months? Okay. Well, while that sits over there and spins, let me just look down here and see what it says. If Bobby Bologna is listening, I went and put some ground beef in the crock pot with some pineapple salsa. Beef in the crock pot with some. Oops. The chicken is frozen and I'm getting hungry. So there's Toodly Pip is here. You know what I just made? I made some Earl Grey tea. I think it's done steeping. I know you're not supposed to leave the tea bags in it, but it is quite delicious. Alrighty. I just wanted to see if this is the point of the... Yeah, it does look like they're going through jury instructions. All right, I hope you don't mind. I'm going to probably have this at a little accelerated pace. I am, let's just say, not impressed with the defense witnesses. I would have liked to have seen people, I don't know, maybe testify to Sadie's rage and her behavior and Zachariah's character when Sadie went into.
There was a request by the state for prisoner status as an issue, and I'm not giving that because that refers to cases where the status as a prisoner is actually an issue. Or when, for example,
again, I count beans. I don't.
Battery by a prisoner.
I don't think we have.
No, I think that could be taken out.
Done.
Done.
All right. You didn't send that?
No.
Okay. Blame shifting. All right. Any problems with the first page, which is not numbered, but first page?
Nothing on the first page.
That's the standard.
Oops.
Then page 2, information, not evidence. The charges. Then.
Judge, in regards to page 2, and I think the state can speak more to this.
There's no audio
they
for
had
the
proposed
video.
Specific language for counts 1 and 2. The defense would have no objection to that, so I'll let the state be heard, but I know that what was included starting on page 2 was.
Sadie should have been on trial, but wouldn't that have gone to like their character? I understood she wasn't allowed to point the finger at Sadie for some odd reason. I mean, isn't that the defense's whole thing, is to poke holes in Dingleberry's Swiss cheese of a case, including alternate suspects? Basically everybody in Rosalio's circle, proving that Zachariah wasn't even in the circle, not even close. The audio was about the jail. Oh, so that was a clue. That was a clue.
Different than what the state had submitted.
You're correct.
In looking at the language for stalking, because there are so many and or propositions, it becomes so cumbersome to read that I wonder if the court would be willing to look at our suggested proposal, because it removes all of the essentially or ones to make it more streamlined and understandable.
Yes,
why do you charge it that way? That's how the information comes to me. That's the charge against the defendant.
Because that's how it is generated in our program, and I can't speak to that. What I can speak to is, I think, the same level
she a
that
victim?
I'm
She
sure
was
the jury
low hole
feels,
in the
which
totem
is
pole.
all of the or this or that. I mean, it becomes very cumbersome. So when I streamline the proposed ones, it specifically has fewer, obviously, or situations, but also it removes a lot of the.
Oh, with the spins. Okay, this is what I'm going to do. I'm going to try this one more time. This worked last time. We'll see. If I lose you, I will start again. Yesterday I had that happen when we were watching that Natalia Grace thing.
Potential ways someone could stalk someone else that don't apply here, which is what the pattern instructions actually call for, is to be more specific.
And we wouldn't have all of these problems had you charged it, because you recognize the problem. The
I hate this. I hate this. Things go swimmingly and then they all fall down and go boom. If this continues, I'm going to have to start a new one. So, all right, for those of you in the sound of my voice, probably on Rumble, I'm going to end this live stream. I'm going to hard reset my modem, and I'm going to set up a new one, because this is just too many problems. The weird thing is I haven't dropped a frame for over an hour and a half. No, 2 hours. And I have full bars. (4,494 kilobytes per second, 60 frames per second. Okay, I'm gonna give you one more chance, freaking internet. Oh. Oh, see, now it's working again. See, maybe I need to threaten more. Now, where were we? Here. Sign in. Dismiss. Fast forward to 2 minutes. And the spins. Oops. Down here again. I just said yes, it's me. Okay. I'm gonna close this live stream. I can't. Okay, see, now here it comes again. All right, if it does it one more time by the time we're done with the end of this, I'm gonna have to just hard reset everything. I don't understand. Things were working really good for a while. I mean, how can we have 12-hour live streams sometimes, and then other days we struggle to get through 3 hours? Threatened you to stop putting NR on my startup every time I signed it. I threatened it could stop that very same night. Yeah, now I have like every time I log in, I have it sends a thing to my phone or my iPad that says someone's trying to log in, and then it's dumb.
This afternoon, and then we'll start with argument.
That's another reason why I don't like using StreamYard, just because
and I won't put
when
a
I
time
use
limit
that,
on
you should
you,
see the
other
garbage that goes
than
on your computer.
when I was a young man,
oh God, more stories. We could have probably shaved off about 8 hours of this
we lived
trial.
across the street from
Oh wait,
Kenneth Brew,
he
who
already
was an eminent
told this story.
matters. There was a request by the state for prisoner status as an issue, and I'm not giving that because that refers to cases where the status as a prisoner is actually an issue. Or when, for example, battery by a prisoner.
I don't think we asked for
No,
that.
I think that could be taken out.
Done.
Done.
I might have
All right, you
fast-forwarded
didn't
a
send
little
that?
bit.
No.
Okay. Blame shifting. All right. Any problems with the first page, which is not numbered, but first page?
Nothing on the first page.
That's the standard. Then page 2, information, not evidence. The charges. Then
Judge, in regards to page 2, and I think the state can speak more to
Soloman.
this, is they had proposed
Yeah,
specific language for counts 1 and 2.
That's probably the only
The
thing I
defense would have
haven't
no objection
replaced.
to that, so I didn't.
Is
I'll
a
let
new
the state be
modem.
heard, but I know that what was included starting on page 2 was different than what the state had submitted.
you're correct.
In looking at the language for
Scott
stalking,
McGinnis,
because
is
there
your
are so
smell the
many
fluffy kind,
and
or is
or
it
propositions,
the
it becomes so
thick,
cumbersome to read
back-breaking
that I wonder if the court would be willing to look
slush
at our
kind?
suggested proposal, because it removes all of the essentially or ones to make it more streamlined and understandable.
Why do you charge it that way? That's how the information comes to me. That's the charge against the defendant.
Because that's how it is generated in our program, and I can't
wonder if I can
speak
get a
to
new
that. What I
modem
can speak
with
to is, I
Amazon.
think, the same level that I'm sure the jury feels, which is all of the or this or that. I mean, it becomes
What I
very
don't
cumbersome. So when
understand
I
is how come I'm
streamline the
getting
proposed ones,
in my opinion,
specifically
fast
has
kilobytes
fewer,
per second.
obviously, or situations, but also it removes
And
a lot of the potential
let me
ways
show
someone
you
can
something.
stalk someone else that don't apply here, which is what.
Let me show you something. Let's see if I can. What happens if I put this up here? Okay, see on the bottom here? 0.1% dropped frames. It was like, we had a whole bunch kind of at the beginning, but look. Kilobytes per second. Green, 45. That's just a test I ran, because this computer does like 10,000, but the receiving side doesn't have that much. And then we got 60 frames per second. And it's, you know, still going. I'm having no red, nothing. So why? Mark? Maybe I should have him. I'll text Mark. Maybe he can hop on and I can show him. He can tell me what's wrong.
The pattern instructions actually call for is
I
to be
really
more
hate to have to
specific.
buy a
And
modem.
we wouldn't have all these problems had you charged it, because
Another expense.
you recognize the problem. The problem is that you divided it in 2 separate instructions, even though there are 2 counts, but I prefer to instruct once on the crime.
Okay.
You have one for Sadie Beecham and one for Mr. Gutierrez.
Correct. So
I propose to give only one.
if the court would be willing, I have access to be able to edit it here. If you would prefer the language of where you have it as of another, and to take out the specified victim's name for counts 1 and 2, I believe that then we could go with the Sadie Beecham pattern instruction, which I believe would cut down on a lot of reading for the court in terms of all sorts of additional options. So if the court's willing to do that, I will make that change here while we sit here and save us all some time.
You make it so I can't even argue with you.
Fantastic.
All right, yeah, please do that, because that the biggest problem was covering all kinds of areas that didn't need to get covered, and the second problem was doing it twice back to back. But if you cure up those problems, then I'll be delighted. So then, and in the meantime, you also had submitted, and both because of some CCAP issues in copying, I didn't eliminate some of those various ways in which the crime can be committed that you spoke of before lunch. And so if you can strike off those that are inapplicable,
Will do.
yeah, that'd be great. Okay, well then let's skip ahead to,
You're gonna need to give her a moment to switch those up though.
all right.
She will not be able to listen.
Sure, we can probably move on. Well, I'm just having to change names. So I know Ms. Muller and I have kind of already went through some of the issues we saw, so I can rely on her to yell some of those out.
Yeah.
Okay. In the meantime, is there any problem with the count 3 instruction?
Yes, the court has the first name of Mr. Gutierrez as Rosales. It should read Rosalio.
Well, don't blame me, that's the computer.
The computer.
Yeah.
Yeah.
You're right.
But besides that, I had no other edits for page 6 or count 3.
Okay. And then the fourth count?
So under the fourth count, under the law, it says, oh, I'm sorry, my computer is being all annoying.
Must be the
It
rule.
says it's the fourth count, and then it says between the date in the city of Kenosha, Kenosha County, Wisconsin, hit a court. So the defendant needs to be added into that.
Oh, I changed did hide. The district attorney is still using language like to wit.
No, sure, but it doesn't have a
and it's-
subject.
Yeah, you're right. That it creates a problem when I change it without putting the defendants because. Yeah, you're right. So I'll put in the defendant hit a corpse with the intent to avoid, etc.
Yeah, thank you. But then there were no other substantial issues with the remainder of that instruction.
Okay.
The next issue that I had come across was on page 11, Judge. The stricken testimony instruction was there for a second time. It was a repeat.
Well, I originally I thought I had taken it out because there was stricken testimony, yes. I thinking that there wasn't, I took it out and then I noticed it was submitted, so I put it back in. So I'll strike it once.
Yeah, thank you. And then let me know when you're ready for the next one.
Okay, improper questions. Well, in evidence defined improper questions, objections.
That was all fine, Judge.
That's where the second time the stricken comes in. Okay.
Correct.
Then testimony of a witness granted immunity or other concession.
Yep.
Any problem with that?
No.
Prisoner or witness. That's the one I don't propose to give. The cautionary instruction.
Yes.
And I noticed I had to put it in at the end so I wouldn't forget about it.
Should I jack up the speed or should we just like peruse through the transcript of this?
Involved in the case.
I'm half tempted to go.
Evidence of other conduct. Any objection to that?
See if I can go to Best Buy and get a new.
No, and I'll just note. I'll just note that that was the proposed language that the defense had provided to the court.
Good. I was able to import that.
Good.
Credibility of a child witness.
Yes, that was requested by the defense.
Any objection? Agreed facts. Any objection?
Nope.
Exhibits. Any objection?
Nope. No kidding.
Circumstantial.
Nope, that's fine.
No objection.
No objection.
Remarks of counsel.
Fine.
Fine.
Closing arguments. Weight of evidence. Jurors' knowledge and expert opinion. Any objection?
No objection, Judge. What the state and myself did confer on, though, was as it relates to expert opinion, we believe 205 should be included because there were a couple of hypothetical questions that were proposed to experts during the trial. So we would just ask that 205 be inserted, and the standard language of that instruction is fine.
Agreed?
Yeah.
Well, let's see. Credibility of witnesses. Any objection?
Nope, fine.
No.
Oh, except that the very last paragraph on that page, the defendant is specified in this case. I won't give that, of course.
Yep.
Impeachment of witness by prior conviction.
So that number, it says evidence has been received that 2 of the witnesses, the state and myself counted that there were 4 witnesses that had prior conviction. So just to change 2 to 4.
Well, actually, what I usually do, and I'm sorry I put the 2 in there, I usually say evidence has received that some of the witnesses.
I think that's fine as well, but the number 2 is.
Either's fine, but 2 is just inaccurate.
Yeah. Defendant elects not to testify. You did request.
Correct.
Okay. The closing instruction.
Looks fine.
Well, actually, it's not. I turn the page here, and first thing I see, the President of the United States, and that's from a different trial.
I'm seeing that.
Gave some instructions about the freedom of the jury to do what they wanted, and not what.
Wonder what trial that was.
Yeah. So I will give
Standard one.
Either the standard or something very close to it. Then verdict submitted and unanimous verdict. Any objection?
No. And no objection there, Judge.
And then that remainder of the questionnaire, that's all out.
Yeah, and then that 275 that's at the end will just be taken out.
Yep.
I didn't have any other notes. I don't know if the state did.
I did not.
Okay.
And Judge, I'm sending to your clerk right now that jury instruction for count 1 and 2.
Very good. Thank you. Thank you. electronically.
Yeah.
Well, yeah, print one too.
Well, here's a copy.
Well, print the copies for them too. So make 4 copies. Huh? It's the same problem I had before. That's, I think that's a CCAP problem.
You able to open it?
Just print it. We'll get it open later.
I can't find it.
Oh,
I will print it to my office. I will want to go get it.
might work.
Okay.
Yeah. Or take, or leave it over.
You can't put a foreign hard drive into the state system.
Well, looks like I'll have to retype everything.
Actually, if
You can scan it in.
which paragraph did you take out? Yeah, I like that idea.
Scan it in?
Well, I can scan it into my phone.
Why would that work? Wait, is that there? Yeah. No, so I'm having a physical copy run over and then it's.
Here, yeah.
But I don't know if it'll let.
Before when I sent the PDF, it didn't work.
But what a bunch of dinosaurs in here, you know? At least she knows what
Yeah, I did type
she knows what she's doing.
If you had the ability, then you guys. I know. And then convert it back to or I don't know if I have that ability.
Even if I have a PDF, that should be fine.
I'm gonna send it to you, Judge.
Except that's, let's see, that looks like the one in the pattern instructions, and that would be unedited.
You wanna see, I have it, I don't have the word version. Yeah. Yeah. Right. No. Yeah.
I'm right inside.
Yeah, it's gonna say, oh,
That is, oh, you have to purchase the, yeah.
Oh, PCAP won't purchase the plan we need converted. Thank you.
You guys remember this? This is just a paper.
Yeah, we can do the electronic version later. You got everything set now, I think. Any other concerns with the instructions?
Not that I'm aware of.
All right, let's call adjourn.
You're going to ask them about 8:30.
I am. Just to acquaint you with the schedule going forward, you're almost done.
Oh, here,
I'm
let's
gonna-
just
I'm gonna
remind them that
instruct you on the
they're
law
almost
this afternoon.
finished.
It's going to take about, I'm going to say half an hour. And
Let's
then
just push the
you'll be released for the
McJustice
day.
system along.
And then I'm going to ask that you return tomorrow at 8:30. Is that convenient for everybody? And we'll hear the final arguments of the attorneys at that time. We hope to be done by noon and have the case in your hands then. That's not a promise, but that's the hope. Like when I told you it was going to be 2 weeks. It was a
Yeah,
hope,
he
and
said he was going to break his legs.
I expect a better result this time
The
around.
one thing.
And I'm going to instruct you now on the principles of law which you should follow in considering your evidence and in reaching your verdict. It is your duty to follow all of the instructions, regardless of any opinion which you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved in the evidence. Consider only the evidence received during the trial, and the law is given to you in these instructions, and from these things alone, guided by your soundest reason received during the best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written, formal accusation against the defendant, charging him with the commission of one or more criminal acts. You are not to consider it as evidence against him in any way, and it does not raise any inference of guilt. The information contains 4 counts of charged unlawful behavior against the defendant, and to each of these counts, he is under a plea of not guilty, which is a demand that the state prove every element of each charge beyond a reasonable doubt. Counts 1 and 2 of the information charge that between the 1st of August 2020 and the 17th of May of the same year, at the city of Kenosha in this county, the defendant intentionally engaged in a course of conduct directed at a specific person, which caused that person,
Hi, Chrissy.
and which would cause a
I just now got to
reasonable
see the
person
chat.
under the same
I'm shopping for a new
circumstances
modem. I'm
to
not
suffer
sure I need
serious
one.
emotional distress or to fear bodily injury or death to herself or himself or to a member of his or her family or household, and where the defendant knew or should have known that at least one of the acts that constituted the course of conduct caused the person to suffer serious emotional distress or place the other in a reasonable fear of bodily injury or death to himself or herself or a member of his or her family or household, and where the defendant's acts caused the other to suffer serious emotional
Chrissy, you're in
distress
Fraser Crane
or
mode.
induce fear in
I
the
was in
other of
Fraser
bodily
Crane
injury
mode trying to
or
make
death to herself or himself
taco
or a member
meat.
of his or her family or household. Stalking, as defined in the criminal code, is committed by
Chrissy,
one
did
who
you see my
intentionally
poem?
engages in a course of
My
conduct
Dingleberry poem?
directed at a specific person, which causes that
I'll
person
put it on the
to
screen on
suffer
the left.
serious emotional distress or to fear bodily injury or death to himself or herself or a member of his or her family or household. It did not come through. What I've got here didn't come through. What was sent to me?
No, the printed copy.
Remember, we gave you a printed copy that we
You wanna
thought
look at it?
Chrissy, have a read
apologize, but that
at the Dingleberry poem that Chat GPT had me
It's just a print out of 1284 is what it is.
had written for me based on my criteria.
Specifically
Although I wish I would have put the
in the
tiny
instruction.
hands thing in
So
it.
it has the
That I understand. That's what the parties discussed and reached an agreement on this. So this is not from one side or the other.
So we know electronically it didn't work, Judge, but we were hoping that we thought the court was going to read the printed copy.
Well, actually, I see now in the latter section, it does remove some of the paragraphs. Okay. Stalking, as defined in the criminal code, is committed by one who intentionally engages in a course of conduct directed at a specific person that causes that person to suffer serious emotional distress, and that would cause a reasonable person to suffer serious emotional distress, and where the actor knew or should have known that the conduct would cause the person to suffer serious emotional distress. Before you may find the defendant guilty of either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. First, that the defendant intentionally engaged in a course of conduct directed at another. Intentionally requires that the defendant have acted with the purpose to engage in a course of conduct directed at the person alleged to be a victim. Course of conduct means a series of two or more acts carried out over time, however short or long, to show a continuity of purpose. Acts that you may find constitute a course of conduct are limited to: 1, maintaining a visual or physical proximity to the victim; 2nd, approaching or confronting the victim; 3rd, appearing at the victim's home or contacting the victim's neighbors; 4th, entering the property owned, leased, or occupied by the victim; 5th, photographing, videotaping, audio taping, or through any other electronic means, monitoring or recording the activities of the victim. This subdivision applies regardless of where the act occurs. And 6th, causing a person to engage in any of the acts described above. The second element is that the course of conduct would have caused a reasonable person to suffer serious emotional distress. Suffer serious emotional distress means to feel terrified, intimidated, threatened, harassed, or tormented. This does not require that the alleged victim have received treatment from a mental health professional. To determine whether this element is established, the standard is what effect the course of conduct would have had on a person of ordinary intelligence and prudence in the position of the alleged victim under the circumstances that existed at the time of the conduct. Third element is that the defendant's acts caused the alleged victim to suffer serious emotional distress. And the fourth element is that the defendant knew or should have known that at least one of the acts constituting the course of conduct would cause the alleged victim to suffer serious emotional distress. You cannot look into a person's mind to determine intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent and knowledge. If, as to the first or second count, you are satisfied beyond a reasonable doubt that all four elements of this offense have been proved, then you should find the defendant guilty on such count, either or both, or neither. If you are not so satisfied, then you must find the defendant not guilty on that count. The third count of the information charges that on or about the 17th of May of 2020, the defendant caused the death of Rosalio Gutierrez Jr. with intent to kill him. Intentional homicide of the first degree, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain who caused the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the fatal act. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the fatal act. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something, while motive may be shown as a circumstance to aid in establishing the guilt of a defendant. The state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If, as to this third count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, then you should find the defendant guilty of intentional homicide of the first degree, as charged in the information. If you are not so satisfied, then you must find the defendant not guilty as to that count. The fourth count of the information charges that between the 17th of May and the 19th of May of 2020, at the city of Kenosha in this county, the defendant hid a corpse with the intent to avoid apprehension for a crime. The Criminal Code of Wisconsin is violated by one who hides or buries a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant hid a corpse. Second, that the defendant hid a corpse with intent to avoid apprehension, prosecution, or conviction for a crime. This requires that the defendant have acted with a purpose to avoid apprehension, prosecution, or conviction for a crime. If, as to this fourth count, you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty of hiding a corpse as charged in the information. If you are not so satisfied, then you must find the defendant not guilty as to that count. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless, in your deliberations, you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses both on direct and cross-examination, regardless of who called the witness. Second, the exhibits which have been received, whether or not they accompany you to the jury room. And third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at the trial. Disregard entirely any question to which I did not permit an answer. Do not guess at what the witness's answer might have been, and if the question is self-suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to the weight of that evidence. Weight of the evidence is decided by the jurors alone. You jurors are the sole judges of the credibility of the witnesses and of the weight of the evidence. During the trial, I have ordered certain testimony stricken, and you must disregard all such stricken testimony. You have heard testimony from a witness who may receive concessions from the government in exchange for his promise of cooperation. This witness, like any other witness, may be prosecuted for testifying falsely. You should consider whether receiving concessions affected the testimony and give the testimony the weight you believe it is entitled to receive. Evidence has been presented regarding other conduct of the defendant for which he is not on trial. Specifically, evidence has been presented that the defendant was involved in growing and selling marijuana and growing and using psychedelic
let's just throw that
mushrooms.
in there.
You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait and that he acted in conformity with that trait or character with respect to the offenses now charged against him in this case. The evidence was received on the issue of witness credibility. You may consider this evidence only for the purpose which I have described, giving to it the weight which you determine it is entitled to receive. It is not to be used to conclude
Nancy, I've told
that the
John Gary
defendant
to
is
read
a
that
bad
letter
person,
about 45
and for that
times.
reason that he is guilty
chooses not to read
of the
it or
offenses
to
now
watch the
charged
video.
against him. The testimony of a child should be weighed
He's beyond help.
in the same manner as testimony of other witnesses. Considerations of age, intelligence, ability to observe and report correctly, ability to understand the questions and to answer them, sense of duty to speak the truth, conduct on the witness stand, interest, appearance, and other matters bearing upon credibility apply to a child witness in common with all the other witnesses. The district attorney and the attorney for the defendant have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. An exhibit becomes evidence only when it has been received by the court. Exhibits which may have been marked for identification and not received are not evidence. An exhibit once received is evidence whether or not it accompanies you to the jury room. It is not necessary that every fact have been proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find him guilty. Remarks of the attorneys are not evidence, and if their remarks suggest certain facts which are not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the lawyers, but their arguments, conclusions, and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under my instructions. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you should take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may testify only to facts. However, witnesses with specialized knowledge in particular fields may give opinions in those areas. In determining the weight you give to these opinions, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based. Only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based upon those facts should not be given any weight. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness has an interest or is disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had for observing and for knowing the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias, or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give to the testimony of each witness such weight as you believe it is entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and experience in your everyday lives. You decide for yourselves the reliability of things said to you by others, and you should do the same thing here. Evidence has been received that some of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. We are going to hear the closing remarks of the lawyers in the morning, and then I will give you about 5 more minutes of additional instruction, and then the case will be turned over to you. We will have 12 of you go into deliberation, and that'll be done by, there's a tumbler over there on the window ledge that you may recognize from your church, or not, but the names of all the jurors we put in there. And if we need to get down to 12, then the defendant will draw out one of the names to be excused. 8:30 tomorrow. And any question, anybody? Even though the evidence is closed, you need to keep an open mind, and you've heard the arguments and those last few instructions. So please continue not discussing the case with anyone, not even fellow jurors. Don't read, watch, or listen to any account of the trial. And any questions? Have a wonderful evening, and we'll see you tomorrow. Anything further today?
No.
One way or another, we need to get I have to print instructions for the jury, so we need to clear this matter up somehow.
Oh, good.
Yeah, when they come over and when I can see the pattern instruction numbers on them, they're always corrupt.
I'll copy these moving forward documents. Big bad, hold it down, we'll assist in this, we'll make every comment.
Thank you.
Please.
Don't be using our somebody checking my stay and you have to hear it. Okay. So I'm not going to see the one block.
All right, so that's the end of day 14. Considering the fact that my internet is pulling some kind of fookery, I'm going to conclude here. I might be making a trip to Best Buy, although I was running some tests. And it seems to be fine. I'm not dropping any. I dropped one frame in what, 51 minutes. So I'm not sure what's happening. And unless I'm mistaken, another 5G router is like $300 I don't have. So with that, if I can get it working again to my satisfaction, so I can actually like do stuff back here instead of stare at spins. I did post a link again to the Tiffany Roy interview with Steve Gosney. I've already showed skeptics the place on the free Zachariah Anderson to find her 4-page report. It's under Unseen Evidence tab, the case, then Unseen Evidence, then at the very bottom, if I recall. I'm not doing it again. All right. So there's that. I really wanted to get the closing arguments in here, but I'm not going to right now. I'm sure you understand. So let's see. I think what I'll do is I'll post on Twitter and I'll post on my Crime Spies page and Discord within like a half an hour if the reset worked, or I'll just resume tomorrow. Pixie's here. June's here. See, I can't even see who's here. Pixie, thank you again for your in lieu of donation yesterday. I mentioned it at the very beginning of this live stream almost 4 hours ago. That was very kind of you. And yeah, well, I've listened to LawKong Express's 4 videos 3 times now with my notes. Another reason why I really would like to just reset this and see if I can get rid of the spins. I mean, we've had a couple 12-hour live streams. That's gone just splendid. I did some tinkering last week, and things were just going great. We didn't have the spins for a while. Now we're getting them back again. I don't understand. It's weird. But like I said, a hard reset. I used to buy me a copy for... You did? Oh, you didn't have to do that, Pixie. No one's ever used that link. Teresa sent $5 through Venmo. I still haven't found my login for that. Nobody's ever used it in the past 9 months. So I'm just used to it. I appreciate you. You didn't have to do that. Let's see. So there's that. Oh, Pixie, you are sweet. Oh, and also I haven't looked yet, but Jamie sent me the link. I don't want to look at it because I'll start to cry and then my nose turns like bright red. And I'm an ugly crier. I'm not 100% sure if this mascara is waterproof, and it just wouldn't be good. So anyway, like I said, I'm going to end for now. And I don't have an out. That's not Christmas. So I'm just going to end for now, reset, and then within like a half an hour, actually probably within 15 minutes, I'll probably figure it out if I'm going to come on over to, EU is on. Okay, well, I'll do that then. And then if you guys want to come back later or tomorrow, I really wanted to get this done today. Alrighty. There's part 2. June, did you see I put that Gypsy Rose Blanchard thing on my Rumbles? I think I sent you the link. June was so sweet yesterday. She invited me for a couple things. And I'm like, oh, well, I've got tax season I got to prepare for. I have a humongous birthday party for my son at my house. It's like kind of like the last big giant hurrah here before I put the house on the market. I'm like, thank you so much, June, for thinking of me. Gets kind of busy. And the triplets are graduating. Yeah, sell the house. You know, there's all that fun stuff. Although I'm not going to miss the winter. Although I can say it's 22 degrees here right now and cloudy. We hardly have any snow. That's actually considered like warm. So at least the last winter, hopefully in Minnesota, is mild. Yeah, my dad turns 80 too. So I said, oh, well, let's just do, you know, my son's turning 21 and we're going to do the Christmas after Christmas. And I said, well, let's just have like one big, huge, giant Christmas after Christmas. Son graduates, dad turns 80. Last big shebang. It's going to be wild, I'm sure. And then the triplets graduate in June. So there's a park that has like a pavilion with a kitchen in it. We're renting for the graduation party because there's a ton of people coming for that, I'm sure. Well, anyway, again, considering the fact that my internet is unstable and I can't really read the chat except for the one at a time thing, I'll just end for now. And I don't even have a goodbye for you, so I'll give you the orange. And then I'll post on Twitter and Discord. Well, I'll see who else has stuff going on because you might be over there. All right, so here's a little goodbye for now.